Item number 18. I have some got a legal document for the petitioner. I'll file an affidavit in that. So one you can
Item number
18.
8.
8. Together.
You have filed some document.
I will file it. Yes,
You will file.
I have got it. Okay.
When do you want?
It may come around 20 November. On 28. 20 mile. 28 mile. 8. Yeah.
Number 1, the bear being made by Mr. A. Rose, learned conflict for the matter is that the turn to be listed on 28. Item number?
I have put it.
Yes. You have put a respondent on the bear being made by Mr.
Data.
Data. Put a respondent number 5. You inform the other thing.
Yes, taken the
The matter is that the turn to be listed after. Yes.
May I please? My lord, I am praying for listing one matter for a reason lordship. Can it be Monday?
Monday. Is there any urgent thing?
At least there.
What matter?
My lord, admission matter.
Admission.
24.
Okay. Admission. Okay. Yes.
Item number 10, lordship.
10.
10, lordship. Right,
You inform the other. It's ESCOR learned standing counsel for the elementary department with consent from the other side, but for this matter after 1 week. There. What matter?
24.
May it please your lordship. Lordship, I beg to mention item number 20, the consent of the other side. We have filed an additional affidavit to bring on record certain facts. It has not come on record. Any other day, lordship.
Right. Airport. Oh. They are telling the of the certain I need to respond for fact. So I have to type this. The lordship may be this around 25th or on 2nd of April.
Okay. Next. Your name?
D. Mohan.
So, learned conflict with consent from the other side press for listing the matter on 2nd December. As she has filed one additional affidavit.
Yes.
Which is not placed on record by the till date. The other hand, Mr. D. Chakraborty, learned counsel responsible for means that he has received a copy of the additional affidavit, and he will file his response and press for on. Yeah.
It is wrong. I am praying to listing of fresh matter tomorrow. The appointments have been made at 2 p.m. today. Matter relates to the appointments of posted teachers and advanced Bengali makeup. Yesterday we filed the petition. At 2 p.m. they are going to be appointed. And it matter to be taken up. I'm deeply offended.
But one six. Mr.
Right.
I.
Yeah.
I, Punya Learned Counsel, appearing on behalf of respondent number 3 and 7 with consent from the other side, but the matter after
significant.
After the fair,
My lord, we have an interim order that may be.
okay. Interim order pass RTO तक
My lord, if my lord pleases, may fix it on 9th or 11th because the pleadings have to be completed. My lord. Therefore,
one minute.
parting, my lord, non-payment of extraordinary benefit, PPF.
Extraordinary benefit. Next week may not be possible.
57.
Yes.
We have picked
Dear learned, the next order complement where to be part with concept from the other side, but fair law.
I'd like to mention for listing. The matter was last listed on 3/9/2025.
When do you want?
List on the next week.
27. What did I beg to mention for listing of a WPC?
What?
The matter is relating to pensionary benefit. The matter was last posted on 15/10/25.
Take it that from
28 November.
I seek your lordship permission to mention as petitioner in person.
Pardon?
I seek your lordship permission to mention as petitioner in person, your lordship. I beg to mention item 12.
Yes.
Your lordship, the cause of action is not anymore subsisting, so I don't want to face it anymore. I therefore request to dismiss it.
Item number?
Item 12.
You want to withdraw this petition?
Yes, your lord.
The petitioner in person submits that he is not interested to pursue this matter, he may be permitted to withdraw this. Accordingly, the players of the subject put on withdrawal.
Bless you.
Item number 28 for motion by VC Moore.
May I please, my lord?
Yes.
My lords, my apologies, I couldn't attend yesterday. I was on my legs, my lords, in a parter before the Honorable Apex Court. My lords, this is a fresh writ petition that we have filed. I hope I'm clearly audible today, my lord.
Yes, yes.
My lord, if my lord would kindly note, we are 15 petitioners. We had applied pursuant to an advertisement of teachers by the government of Assam. My lord would kindly find the advertisement at page 77, P3. The advertisement was for placing us or inviting applications, page 77, P3, my lord.
Yes.
This is the advertisement, my lord, and by which applications were invited for the government-run schools for teachers on various graduate and postgraduate categories. In this, my lord, one clause is important. At page 82, my lord may see the clause. Page 82, clause F. Page
Yes.
82, clause F for Finland. If I may read, my lord, application seeking condonation / relaxation of any criteria should be made to the appropriate authority as per applicable norms at least 7 days prior to filling up of online applications. This is a clause which comes in the advertisement, my lord. This clause comes from the original rules of recruitment, my lord. The rules, my lord, would kindly find at page 50. This comes from the recruitment rules. Page 50, if my lord would see, is the relevant rule at 31. Page 50, rule number 31, relaxation. So this is the origin by which the present clause, as I read, comes. If I may read the rule.
Yes.
where the government is satisfied that the operation of any of these rules leads to undue hardship in any particular case, it may dispense with or relax the requirement of that rule to such extent and subject to such conditions as it may consider necessary, dealing with the case in a just and equitable manner, provided that the case of any person shall not be dealt with any manner less favorable to him than provided in these rules. This is the original rule. Now, what is the controversy in the present case, my lord? I would want to take a minute on that. My lord, we were doing Bachelor of Education, B.Ed, from a university which had to publish the result by a fixed date. The date, my lord, would find at page 196. This is very, very important. Page 196, annexure P7, is the date sheet that the university published. Page 196, if my lord would have. My lord would see on the second row, the session is mentioned. Session is 22-24. On the top second row, first column, second column, first row, session is 22-24. I am of that session, my lord. And B.Ed is of 4 semesters. My lord would kindly see the last row, which says publication of semester results. Publication of semester results is in the second week of November 24. This is the date sheet by which I was doing my B.Ed. All of us, all 15 of us were doing, and they had to publish the results by second week of November 24. My lord would also make a note here. The last day to apply in the present advertisement oblique recruitment was 20th November 24. That is very, very important. The last date to apply in the present advertisement.
Where it is mentioned?
Well, that is one notice we have put in one notice which extended the date up till the 5th of November. And then there is another notice which, if we can just tender, my lord, we have a copy of that, by which it was extended to 20th November 24. If my lord,
part of the record.
my lord, what has been put is a notice which extends it to 5th of November 24. Thereafter, there is another notice which extends it to 20th November 24.
Whether those 2 notices are part of the record?
Up till 5th November is a part of the record. Up till 20th November, we are carrying copies. If my lord would want, we can tender it. Or there is an order of this court which records 20th November. Can I just show that directly? It is an admitted fact. Kindly see, my lord. Kindly come to page 173. A previous writ petition by the same petitioners on a different ground. There, an order of this court records that it was extended till 20th November 24. Kindly come to page 173, para 3. That notice we are carrying copy, but it is included as a matter of fact at page 173, para 3, if my lord would have.
Yes.
My lord would kindly see the last 3 lines of para 3. The said addendum was followed by a notice dated 12th November 24. By which last date of filling up the online applications was extended till 20th November 24. My lords, I have page 173.
Yes.
Thereafter, my lord, so 20th November 24 was the last date. 9 days prior to this, a representation is given to the government of Assam, which my lord would find at page 58. The original copy is at page 60. The original copy may be seen, the typed copy is above, page 60 may be seen, 60. My lord would kindly have on the right side at page 60, there is a stamp and there is a date of receipt, 11/11/24. And then, my lord, it is addressed to the Director of Secondary Education, who is the concerned authority, as per that clause of F, saying request for granting eligibility to apply for TET cum recruitment process. Respected madam, we the undersigned students of so-and-so are writing to bring to your attention a pressing concern regarding our academic career. Despite for our appearing in the 4th semester in the September month. So this is in consonance with the date sheet. Approximately 5,000 students are yet to receive their results. The said result is expected to be out by mid of December. Meanwhile, our batchmates from the 22nd-24 session have already been permitted to sit for the examination. The batch remains the same. In light of this unforeseen delay, we humbly request that you provide us with an opportunity to sit for the examination by making the correction card. We would greatly appreciate your consideration in this regard, ensuring our academic progression remains uninterrupted. This is a representation given by the petitioners herein to the government, my lord. This is 9 days prior to the last date. I am specifying on the number of days because the rule, as we read in the advertisement, said that 7 days prior at least you have to apply for any relaxation. So I make a representation 9 days prior saying that kindly relax this rule because the university had to publish the results and the university is delaying it their end. Not just this, my lord, I also write an email to them. I also request for multiple emails that I send to them that my lord would kindly see at page 62 onwards, the very next day, very next page, 62. 62 onwards, the date is important, 14th November 24. I write to NCT and there is a series of emails. First to the NCT, second to the Honorable Chief Minister Assam, and continues, my lord. In fact, 24 is important. That is another mail sent on 25th October 24. And then my lord would kindly see page 66 also. This is an email written by me to the university because the university is based out of Bengal. At 66, I have written much prior an email to the university that despite giving the exams in September, your date sheet says that the results will be published by second week of November. The last date to apply is 20th. The subject itself I have mentioned at page 66. And then my lord would kindly see page 67 also. 67, the subject is important and the date is 27th October. To the VC exam controller, registrar so-and-so, urgent request for early publication of B.Ed final semester. So this is a request that I make to them. And continues, my lord. There are a series of mail which I will not trouble my lords with. Then what happens is, my lord, that there is a corrigendum passed by the government by which this relaxation clause in the advertisement is withdrawn without any notice. That corrigendum, my lord, would find at page 114. And this is important because I am before my lords on two grounds, which I will just explain. At 114, my lord would see the second paragraph is important at 114. Moreover, the procedure, application seeking condemnation, relaxation of any criteria should be made to so-and-so under the head of so-and-so for filling of vacancy, so-and-so are hereby withdrawn. The last line says are hereby withdrawn. Now, my lord would note that the rule pertaining to recruitment still has that provision where relaxation can be given. The clause in the advertisement is included as per the rule. Now, this corrigendum as well as the representation is a subject matter of the present writ petition. I am seeking relief from my lords on two grounds. One, that a representation is given on time. As per the advertisement, it had to be given 7 days prior. I have given that representation. My representation is not decided till today that whether a relaxation is being given or not being given. That is the first ground which I have come before my lord. The second ground is that there's a constitution bench judgment of the Honorable Supreme Court, which I will take my lord through, which says that after the date of advertisement, any change in the rule, which is not as per the original rules, any change in the clause is not permitted. Therefore, this corrigendum at 114 is also a subject matter of my present writ petition, where I am seeking a setting aside or quashing of this corrigendum. Why? Because it changes the rules of the game. Specifically, when the original rule as per the recruitment rules is not amended, that rule continues. but only the clause in the advertisement is withdrawn, which makes the advertisement contrary to the rules. So on both these counts, I am requesting before this court that this particular annexure P4 may be set aside and quashed on both these grounds. And directly coming to the Honorable Supreme Court's judgment, my lord, it starts at 115. This corrigendum is hit by the judgment at 115. This is the 5-judge bench, the Constitution bench judgment of Honorable Supreme Court, which says that post the advertisement date, the rules of the game cannot be changed. As I said, on the date of the advertisement, there was a clause. The clause is subsequently withdrawn, but the corresponding rule is not amended. The rule still stays. The rule says that yes, relaxation can be given because ultimately, my lord, if the university is delaying the result, it is beyond my control, is my case. Despite me sending 10 mails to them, the university has not acted upon it, and the government has chosen to not respond to my representation. Therefore, this judgment is important. Kindly see 115. 115, the judgment starts, my lord. Para 1 is important, my lord, at 115.
Yes.
I am reading para 1, my lord. A 3-judge bench of this court, while accepting the salutary principle that once the recruitment process commences, the state or its instrumentality cannot tinker the rules of the game so far as the prescription of eligibility to the procedure for selection is concerned. This is the context on which this reference was made. Directly, my lord would kindly come to the conclusion. Which my lord would find at page 156. Page 156.
Yes.
My lord would kindly see para 42. We therefore answer the reference in the following terms. Recruitment process commences from the issuance of the advertisement. That is very, very important. Advertisement calling for application and ends with filling up of vacancies. Second, eligibility criteria for being placed in the select list so-and-so commencement of the recruitment process cannot be changed midway through the recruitment process. This is very, very important. Unless the extent rules so permit, or the advertisement which is not contrary to the extent rules so permit. I would pause here for a second, my lord. What is being said at 157 is that if the recruitment rules say that you can change the criteria or you can withdraw the criteria, no problem. But if the rules don't permit, such modification cannot be done at the same time if any such modification is being done. I'm sorry.
No. The question is, can it be said that by issuing that corrigendum, the respondent authorities have changed the eligibility criteria as stated in this point number 2 of paragraph number 42 by the Supreme Court?
Yes, my lord, I will directly answer that. The answer to that is this. Kindly see for a minute, my lord. Point number 2 once again with me for my satisfaction. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extent rules so permit, or the advertisement which is not contrary to the extent rules so permit. Now, my lord put this question to me, that is the eligibility criteria being changed. I want to highlight one aspect. There is one document on record which I want to show, that this is not the first recruitment the government is going ahead with. There have been multiple recruitments the government has carried out previously. In every recruitment, save and except the present one, government has permitted or relaxed the criteria that anyone who has appeared in the final semester and the result is awaited can appear in the examination. Just see one such example with me to show that everywhere the government has taken a common stand in the recruitment process in consonance with the rules, that if you have given your final examination but result is awaited, which is my case.
No, but Mr. Counsel, that is not the answer.
My lord.
The question put by this court.
My lord. Would my lord kindly come for a minute just to page 198? I will directly answer that. Kindly come to page 198. 198, annexure P8.
Yes.
My lord would see, this is dated 1st October 2021. and this is issued by the Additional Secretary Government of Assam to the Director Secondary Education. Subject is important, my lord. Regarding acceptance of application in respect of candidates who acquired completed B.Ed during the year 2021. Kindly see the contents, my lord. Sir, with reference to the subject cited above, I am directed to inform you that the Government in Education Department has approved the proposal of DSC Assam, communicated by letter dated so and so, and is pleased to allow the candidature, this is very, very important, of the TET qualified candidates who passed acquired BA degree from NCT recognized teacher training during the year so and so, after passing the TET examination against the advertisement dated so and so. My lord may note the date of the advertisement 8/9/21, and the date of this letter is 1st October 21. This is very, very important. The advertisement is dated 8th September 21, and the relaxation which is being given is on 1st October 21. So, what is essentially being said here? The advertisement, which was a backdated advertisement, because there were representations made, whoever was sitting in the examination or continuing will be eligible to participate in the recruitment process despite the fact that on the date of the advertisement he did not have the final result. This is Government of Assam's notification for a prior recruitment. So the point that I'm trying to answer, which my lord put a question to me, that is the eligibility criteria being changed, that is one part of it. Absolutely no problem. The second argument that I'm canvassing for my lord's kind consideration is this, that there is a corrigendum which is contrary to the rules. The rule 31, which I read for my lord's convenience, stands as it is. The rule has not been changed. So therefore, the moot question today for my lord's kind consideration is that when the rules prescribe a manner and the rules say that a relaxation can be considered, I'm not saying granted, can be considered. Can the government, after the advertisement has come in and the recruitment process has been put into place, make a decision which is contrary to the rules? Which is contrary to the rules. That is the argument that I'm trying to canvass before my lord. And before that, my lord, I just read the conclusion of this Tej Pratap matter. If I show the discussions, my lord, the entire discussion goes on to the fact that anything that has been done in the advertisement, whether changes, etc., even if the advertisement had, I go ahead and say that if the advertisement did not have this relaxation clause, could the advertisement be accepted in light of the rule? If my lord would be kind enough, kindly see the rule with me once again.
No, you have already told
Yes.
her.
So therefore, what I am saying is, and therefore my prayer in this present writ petition is very, very important. The prayer at page 25, my lord, is twofold. One, that I have made a representation. The representation should have been decided whether positive, negative, that is the government's call. The representation has not been decided till date. And second prayer, my lord, that because the representation has not been decided, the document verification that they have conducted for me has not gone through in the right light because of this relaxation that they should have considered. As I say, that whether they have to decide positively, negatively in light of their previous conduct, that is left to them. That is not something that I can pray for, that they should decide it positively. But the fact that there is a representation, as on the date of existing rule, as on the date of existing clause, they are duty bound to decide it, is my humble submission. And therefore, my lord, at the third prayer I also seek is that because I have written multiple times to the university, that it is not something that I have delayed on my purpose. As per the date sheet of the university, I had to get my degree or the result prior to the last date of applying. Now, this is something which is beyond my control, because university says, when I inquired, and I have also filed an RTI which I will place on record if my lord would permit, the university says that the
Mr. Counsel, if say that university is outside the jurisdiction of this court,
my lord. Yes,
Right.
yes, the direct answer is this, my lord. There are judgments to say that we are not challenging a decision of the university. If it was a supervisory jurisdiction that my lord were exercising under 227, then the territory will come into picture, which is, my lord, is absolutely right. But the fact that I am not challenging a decision of the university, I am not invoking Article 227 in the present matter. Therefore, my lord, whether the university is situated within the state of Assam or outside will not be material. If required, I will place some judgments on record that for Article 226 petition, my lord, because it is not related to territory, even if there is a university placed outside, specifically when there is no challenge to the decision of the university, there is no decision that I am challenging. The only thing that I am trying to point out is that when I approach the university, that why have you delayed my result? I need to apply 7 days later. What was told by me to the university told me is this, that because there is a cyclone in the state of West Bengal, because there is that RG Kar unfortunate case, my lord, that medical incident that happened, and because there was no registrar, these three things are the reasons by which the university delayed the result. Would my lord want to see Article 227 and 226 with me for a minute?
You place those judgments before this court, we will examine.
We'll do that. And there is also one more thing which I wanted to state, my lord. In all fairness, my lord, there was a previous round of litigation where there was a writ petition, where there was a writ appeal, and where there was an SLP filed, my lord, by the same petitioners. And I placed the writ petition on record, I placed the writ appeal on record, I placed the SLP on record. I placed the 3 orders passed, which I will show my lords if my lord would want to see. But the representation and the corrigendum, both these things were not the subject matter of those proceedings. If my lord would want, I can take my lord through the order of the writ petition, take my lord through the order of the writ appeal, and take my lord through the order of the SLP.
Not necessary, but whether those orders are part of this record?
Yes, my lord. They are directly a part of the record because...
All right.
Yes. And there is one last thing that I wanted to say, my lord. Kindly come to page 277. Page 277, if my lord would have for a minute. This is the latest notice that they have issued, the government of Assam, because the proceedings of this recruitment are going on. And my lord would make a note of one more point. I participated in the process. Before my lord sees page 277, just give me 1 minute on this. I participated in the process. I am much more meritorious than the people who are being appointed, have not been appointed, but are being appointed. The only reason which my candidature was not being accepted is because my marks or my result has come after the last date of the advertisement. But prior to document verification, I had my mark sheet. So it is not a case where less meritorious aspirants are coming before my lord seeking equitable relief. That is not the case. I can show from the merit list that I am much more meritorious than the people who are being selected. And because of no fault of mine, despite giving representation to government on time and the university, still my candidature is not being considered without considering my representation. And page 277, I wanted to show for this reason, that they say that this is a notice of 30th October 25, my lord, 12 days ago. In continuation to this office, earlier notice so-and-so. This is for the same advertisement, my lord. An online portal will be available from so-and-so, which will facilitate the candidates to opt for all available district in order of their preference. Candidates will have to log in by entering by their application number and password used by filling up so-and-so. This is important, the third paragraph. The final district allotment is subject to availability of the post in the respective districts in order of so-and-so. The final posting of a candidate in a particular school of the allotted district shall be finalized by the concerned authority in due course. However, the decision of the government shall be final and binding. Timing will be so-and-so. The point that I am trying to show this is, my lord, that the process to issue the appointment letters has started from today. They are about to issue appointment letters from today for all these 5,500 posts, because what was advertised was 5,500 posts. The petitioners before my lord is 15 of us. The request that I wanted to make, and my lord were kind enough to list the writ petition on an urgent basis, or else it would have been rendered infructuous, that, my lord, till the time my writ petition is being considered on merit, my lord, there is some interim protection my lord would consider. And what is the interim protection? In all fairness, I would submit, my lord, there could be two ways, my lord. Either my lord would consider that 15 posts, because not all 5,500 posts are being filled, only about 1,200 posts will still be left vacant. The difficulty is this, my lord, that tomorrow if I am able to convince my lord on merits, specifically the fact that there is no representation that has been approved, and all 5,500 posts are filled, the government will come and say that now it is an academic in nature, we have appointed teachers who are less in merit, and therefore nothing can be done. The only request that I want is, I don't want to come in the way of the government in any manner. 15 posts may be left vacant for us till the subject matter is decided. Only 15, not 5015. And those are the number of petitioners. And I have absolutely no problem if my lord would want me to place those judgments tomorrow itself. My matter can be kept tomorrow. I will argue it out with those judgments that there can be direction issued to a university outside the state, because this is an Article 226 writ petition, not a 227 one. Plus, my lord had put this question to me that if it does not relate to eligibility, can still there can be a challenge to change in the rules, because the original rules don't permit. There are sufficient judgments to show that, for even if it's not about eligibility, but if the rules don't permit, even then there can't be a change midway. In fact, I had the occasion of arguing recently a matter before the Honorable Supreme Court pertaining to Jharkhand, which was not about eligibility, but the rules were changed midway when the original rules were, the advertisement was modified midway when the original rules did not permit. And the Honorable Supreme Court struck down that if the original rules don't permit, you cannot modify the advertisement in any manner whatsoever. So I will place that on record. But this interim protection, either, my lord, 15 posts may be left vacant out of 5,500. I don't think I'm making an unreasonable request that 15 posts can be left vacant till the time, my lord, the writ petition is decided. That is my short request that I'm making, my lord. And, my lord, I showed these documents that everything possible by the petitioners was done. Everything possible. And why was there a legitimate expectation? Because the government in a previous recruitment 3 years ago had done this. That if you are appearing in an examination, we will consider you. That is what the government has done. And that has not been challenged. That is the notification that I just showed. So therefore, at the time of applying, there was a legitimate expectation that because the government's conduct has always been that anyone who's appearing in the exam will be considered, therefore I applied, and therefore I am higher on merit. Even my TET marks show that I am much higher on merit. And last but not the least, I am so grateful that my lords have heard me so patiently. Ultimately, my lord, it is a matter of quality of education to the students. If a teacher who is less meritorious than me is imparting education, my lord, ultimately it is the society which will suffer. And specifically when it is not my fault. Therefore, the date sheet is important. The date sheet categorically says 2nd week of November. And the last date admittedly is 20th of November. So therefore, when all of this is being done, my lord, and there is no fault of mine, hence, my lord, the government should have either decided my representation, or, my lord, they should have considered me for this post specifically when I'm higher on merit. So therefore, all that I'm requesting is, my lord, may kindly consider this interim merit.
Okay.
I'm so grateful, my lord.
Yeah. Why the representation has not been disposed?
It is not required, but the lordship dispose of this case by directing us to dispose of the request within 3 days. It will do it. But I have a lot of other things to argue. But if that is the only prayer, then I have no difficulty. I will tell the government to dispose of their request within 3 days.
Yes.
No, that is not my only prayer. My other prayer is also to set aside the corrigendum. Because then they will say that because the corrigendum has been passed, therefore we have no power, therefore we are dismissing the representation. So therefore there are two prayers.
He is judging our order. He is judging, he cannot. If lordship directed, we have to dispose of the application, which we have annexed the page 15. Otherwise, there is absolutely no case at all. Page 58, 11/11/2025. Last date was 28th of November 2020. Now, when this representation has been filed, day is, I think, 13. Day before yesterday, they filed this representation.
Because the reason is that the merit list has only been published 7 days back. the final merit list, as per, I'll put those. In fact, the government should have put those circulars, but I will put that circular after the last notice that I showed. It is only after that the final merit list has come out, and I don't feature in the merit list because my representation was pending. I had the belief that I will feature in the final merit list because I'm much higher on merit than the people who are being selected. Because, my lord, as per this, there is a TET exam that is conducted. There is a cutoff mark given. My marks are much higher than the people who are being selected. So it is only in the final merit list that I get to know that I'm not being selected. And why? Because my representation has been kept pending. There is no speaking order passed on my representation despite giving it well in time. So
Okay.
therefore, the challenge is both, my lord. I am challenging that there can be no change in the rule or change in the advertisement unless the rules permit it. If the rules say that you can change it, no problem. But if the rules say that there has to be done in an X manner, unless the rules are amended, the advertisement cannot
Okay.
be
Okay.
contrary to it.
Okay. All right. Yes, Mr. President.
So, Lordship, day before yesterday, this representation has come. If at all it has been filed, because if we look this presentation, yes, they have submitted there the skill, and it's also page 60 is the original one. May I read this? What is this presentation all about?
Hmm.
We, the undersigned students of Baba Saheb Ambedkar Education University, Kolkata, are writing to bring your attention a pressing concern regarding our academic career. Despite our appearing in fourth semester examination in September month, which they have not taken, approximately 5,000 students have yet to receive their results. So, till now, they have not received their results. From their language, I'm not reading from my document. The said result is expected to be out by mid of December. That means 2 months later. They are not mentioning the year. Meanwhile, our batchmate, I'm sorry, Lord, it is 11/11/2024. Yes, in the type copy, it is 25.
No, I'm sorry, my lord. The original copy is 24 only. The type copy there
So
could be a typo error.
I started by reading the original one, this one, the type
No,
copy.
please see the original copy. The
Let them
original
first
copy.
amend this petition. Let them first amend this here. Whether it is 24 or 25.
No, the original copy is very clear, my lord. I'm sorry, such kind of objection is coming. Kindly see page 60. The original copy.
Because my argument will be totally different. If it is day after before yesterday, my argument is different. If it is 1 year ago, my argument will be totally different.
It is 1 year before. Kindly see page 60. Page 60.
I was not interfering.
In fact, the date, I'm sorry, my lord, just on factual aspect. Page 60 may be seen. Forget my date, see the date of receipt. That is important. Page 60 has the stamp and the date of signing of the government also. Page 60. And it is not at one place, it is at two places. At 61 also, there is a stamp of the government with the date. Page 61, bottom of the page, the government stamp is there and the date is.
Okay. Let the counsel for the respondent respond.
My lord, that interim protection, my lord, may kindly consider.
My humble submission, I have to verify whether it was actually submitted day before yesterday or 1 year ago. I have serious doubt now. Let me verify. Let the matter come up on Monday. I'll verify whether this representation was actually submitted day before yesterday or not. There is a seal and a date. There is no signature. Whether it was actually submitted to the dispatch section of the education department or not, I have to be. This can be a bogus one.
If it is a bogus one, my lord may dismiss my writ petition with cost. But if it's the right one, then my lord will kindly consider allowing my writ
petition. One, then I'll submit before the court.
Yeah, then my lord will kindly consider allowing my writ petition. And if it's a bogus one, my lord may dismiss it with costs. I am submitting as a petitioner's counsel that if that is the extent that my lord, the AG would want to make submission that we'll produce something bogus, let him verify. Absolutely no problem. But if it is bogus, my lord may dismiss it with costs. I'm saying that with responsibility.
Okay.
And
Okay. Yes, Mr.
So now, what is this case all about? He is basically challenging the agenda, which is at page 114. So this is the bone of contention. It pursuant of government order dated 21/12/2020 when subsequent OM dated 4/5/2020. The reservation criteria clauses for GWS category mentioned in the advertisement dated published in local dailies for filling up the vacancies of postgraduate and graduate teachers, both government and private, are hereby withdrawn. So whether if lordship this is challenged, then this part will also, they have specific that only the second part they are concerned that they have a difference. Moreover, the procedure application for seeking condonation relaxation of any criteria should be made to appropriate authority as per applicable norms at least 7 days prior to filling up of online application. Appeared at F. Please note in the advertisement dated 26/12/2023. Published in the local dated on 27/12/2023 for filling up of the vacancies of postgraduate teachers and graduate teachers of both government and provincial and secondary schools are hereby withdrawn. So there are two parts in this notification. Let them first tell this court whether they are active by both the conditions which are withdrawn or only one condition. That is number one. Now, Lordship will kindly take the date of this. This was issued. It's not there. I am not find the date, but I am told it is 15th March 2024. Lordship will kindly take the note.
15th of March.
15th of March 2024. We are in November 2025 now. So there is a delay of about 20 months. 20 months delay. Whether that can be condoned or not. So after 20 months, they have waken up from their slumber. It is number one. Lord, kindly mark that date. Now, Lordship will kindly come to the advertisement. Advertisement page 77. May I read?
Yes.
First two paragraphs very important. Applications are invited from eligible Indian citizens defined under so and so for filling up of 205 vacant posts of graduate teachers, graduate science, graduate teachers, etc. of different government secondary schools under the Director of Secondary PSL of the district-wise, subject-wise, medium-wise, category-wise post details, as well as date and time and receipt of online application for TET, some recruitment test and other details will be notified in official website at www.madhyamik@assamgovernment.in in due course of time. Vacancies may vary due to administrative reasons. The Director of Secondary Education reserves the right to make changes in sequence of recruitment process after publication of this advertisement. The advertisement itself, in paragraph 2, says that it is a notice for all the candidates to look for the advertisement. The advertisement is not finalized on that day. In paragraph 2, very categorically, the department has said, the employer says that the district-wise, subject-wise, medium-wise, category-wise post details as well as date and time of receipt of online application for tax term recruitment test and other details will be. That means in future will be notified in the official website at so and so in due course of time. So this advertisement is not complete on that day. Further, vacancies may vary due to administrative reasons. The Director of Secondary Education reserves the right to make changes. So he has reserved his right to make changes in the advertisement. What he has said, the right to make changes in sequence of the recruitment process after publication of this advertisement. So he has reserved his right to change the advertisement. Now coming to page 81, NB, at the center.
Yes.
The applicants are requested to visit www so and so in regularly for any update. Update of what? Update of the advertisement. Originum and addendums will be published as and when required in the official website www.madhyamik. So that is also indicated, will be published. Document up to date as mentioned below should be colored scan. So this is not relevant. So 1 and 2 bullet points are relevant. So advertisement itself from the very first day says that they will have to keep themselves updated with the various updates in the website regarding any changes in the conditions, regarding the vacancy position, regarding the total notified vacancies, regarding the category of posts, regarding the district-wise vacancies, etc. Now, eligibility, Lordship will kindly come. Conditions of frequent page 77. So, A, minimum educational and professional qualifications for direct recruitment in the post of graduate teachers, arts and science. So, these are the eligibility criteria. I am not going to read out the whole list of eligibility criteria. And B.Ed is a mandatory condition, the eligibility. Now, coming to the clause at page 82. F. It is what has upset the restriction. Application seeking condonation relaxation of any criteria should be made to appropriate authority as per applicable norms at least 7 days prior to filling up of the online application. So this clause was later on written. And what actually intended by this that there are a lot of requests come for condonation of age in service candidate. So those are as per norms by this state, application seeking condonation relaxation of any criteria should be made appropriate authority as per applicable norms. This applicable norms is very important because we have to see if there has to be any change. Suppose there are shortage of candidates in SC Hill, that we can make a request that kindly give those vacant posts to SC Plain. That kind of adjustment can be always done, but there should be some application. And in case of in-service, there is always the upper age cap for the eligible candidate. They can make a request for giving some relaxation, and that is permissible under the APSC regulation as well as various service laws in force. A particular age can be relaxed. So in those applicable norms, this clause is applicable. So why the government has decided that we have, suppose for what is the vacancy, I will come to that later. Suppose that there is 5,000 vacancies. In elementary, we got 55,000 applicants for regular candidates without any this kind of application. So here also the identically for suppose one post is there are 25 applicants. So the ratio of applicants with the notified vacancies is much wider. So there is no shortage of candidates. So there is no scope for any consideration by the government on a lenient view to relax any of the norms. And norms, so far as recruitment conditions are concerned, Lordship, recruitment conditions concerned are basically the eligibility criteria. The report has also indicated, Lordship, that there is a report. Eligibility criteria in any recruitment process, that is condition of recruitment, is never, cannot be tinkered with, cannot be diluted. Only service conditions can be tinkered with. That is the settled position of law of this division bench of this honorable court as well as of the Supreme Court. That one can always give relaxation in respect of service conditions. Once a person enters into service, there can be some relaxation. But at the point of entry, when the recruitment conditions are in force, at that point of time, in my humble submission, the law is well settled, very strictly settled, that it cannot be tinkered with, it cannot be diluted. So the eligibility criteria as conditions of recruitment, page 77. These conditions cannot be tinkered because this has a statutory value and the law is well settled that we cannot make any relaxation. There is a 50% mark for graduation. So we cannot bring it to 45%. Or if there is a requirement of a particular subject, we cannot change the subject of eligibility. So conditions of recruitment cannot be changed. That is well settled. But I can say for the justice. Now, this date is, although the date is not mentioned in this document, page 114, The advertisement at page 77, Lordship will kindly mark the date there. Is of 26th of page 82, Lordship will find after Mamta Hosai's signature down below. Date 26/12/2023. So in the year 2023, in the month of December 26, the date this advertisement was issued, and the advertisement very clearly says that in future the exact details of the advertisement will be notified. Paragraph 2 of page 77. This correction term came in the month of March 2024. That means after 4 months. And thereafter, the addendum has come. Page 101. Now the advertisement is complete here. The language, page 101, addendum, Lordship will mark the first two words. In continuation of this office earlier advertisement dated 27/12/2023, that is newspaper reporting, the newspaper publication, this information to all concerned that the breakup of the post of graduate teachers for recruitment in the government secondary school under the Director of Secondary are as follows. So complete details have come up in this advertisement. Therefore, it is a continuation of the earlier. Now the advertisement is complete. And how to apply? The application window has been opened now. Now in this advertisement, the first part of the advertisement did not indicate how a person can apply. Here the details of application procedure has been laid down. Number 1, interested candidates are requested to go through the terms and conditions of the advertisement and may apply to the official website of so-and-so. No other means, mode of application will be accepted and the application will be summarily rejected. The online applications will be accepted from 21st October 2024, 11:30 a.m. to 15th November 2024. Subsequently, there was another addendum which has enhanced this date from 15th November to 28th of November. So, after issuance of this addendum, the recruitment advertisement has come to a final shape. In the meantime, the corrigendum was issued to withdraw clause number F, which I have placed, which is under challenge now. And thereafter, the applications were accepted. And most interestingly, Lordship, the applications were filed by them. They have also applied without having the BA degree. So, they have accepted everything. They have accepted the conditions of the advertisement, original advertisement of December. They have accepted the corrigendum of 15th March 2024. And finally, they have accepted the addendum of October 16th October, page 106, will get that date, 106, 16th October 2020. And very happily, they have submitted their application. And their candidatures were rejected because they did not have they did not fulfill the eligibility criteria because none of them were having BA degree on 28th of November 2020. The rule is very clear. The last date of submission of application, you must acquire all your qualifications, whether it is professional qualification or it is educational qualification. Unless the advertisement itself shows. And they have challenged their rejection at page 172, the learned single judge by order dated 1/8/2025, rejected identical cases
Page number
172. My Lord Justice Nelson Silo's order. Here they did not have the, if the lordship is pleased to look at paragraph 3. Facts of the case in brief order, the Director of Secondary Education Assam on 26/12/2020 floated 2 online advertisements for filling up of 200 posts of graduate teachers so and 7,049 posts of similar same in different provincial schools. The candidate petitioners responded to the advertisement by submitting their respective applications and documents online before the last date of submission of their form. Be it stated that the director had issued the addendum of 16/10/2024, which provided that online applications should be accepted from 21/10/2010 to 15/11/2024. The said addendum was followed by a notice of 11/12/2024, which the last date of filling up of the online application was extended to 28 November 2024. Then their main issue is paragraph 6. Mr. K.K. Mohanta, learned senior counsel, submitted there is no provision or scope for submission of the credentials along with the application form, and therefore the petitioner could not submit the same. He submits that the production of testimonials on the state for verification of documents is a normal procedure, and the petitioners made such requirement of producing the same on the date for document verification. May I pause here for a moment? They have submitted their application on by 28th of November 2020 by entering that they are having a degree and all fulfilling all the eligibility criteria. Subsequently, we have a process of verifying the document. On the verification, at the time of verification, it was found that none of them has the eligibility, fulfill the eligibility criteria by acquiring or obtaining the BA degree within the stipulated time, that is 28th of November 2020. It was subsequent there. They have acquired a BA degree, but after the timeline was over. So deadline was over, so the law is well settled. Therefore, on that ground, the case was dismissed. All these cases were decided at our government submission at paragraph 12. Paragraph 12, we have submitted that on the date they were not qualified. And finally, the learned single judge paragraph 24, the case was dismissed. They went to the division bench. The division bench noted the issue at page 188. The short issue, I have brought it, is 188.
Yeah.
The short issue which arises in this appeal is whether the appellant could have been allowed to cure the defect, especially in view of the scheme of examination, when at the time of verification, the document had to be produced regarding eligibility. The submission raised on behalf of the appellant is not justified. It is a right that eligibility for participation in a recruitment process has to be determined with reference to the cut-off date stipulated in the advertisement, namely the last date of submission of applications, unless the rules provide otherwise. The rationale is twofold. First, to ensure fairness and a level playing field by treating all aspirants alike. Second, to ensure administrative certainty so that the authority may freeze the seat of eligibility on a given date. If candidates who are ineligible on the last date are allowed to acquire qualifications subsequently and yet participate, it would amount to conferring upon them an undue advantage, while others similarly placed but who refrain from applying would stand unfairly excluded. The proposition has been made by Supreme Court in so and so cases, though the applicant has secured better marks than other experience, but unfortunately did not have the eligibility on the last date of submission of the application form. The appellant had applied against an advertisement of 26/12/2023 issued by the respondent. They were allowed to appear in the examination subject to their having the requisite eligibility, which would have been verified at a later stage. The appellants were required to have BA degrees, which they had acquired only after the last date of submission of the application form on 20/11/2024. considering this aspect of the matter, the learned single judge did not agree to allow the case of the appellant's writ petition. We do not find any illegality or perversity in the order for us to interfere. There is no merit in the appeal. The appeal stands against that. They went to the Supreme Court. The Honorable Supreme Court, at the verge of dismissal of the SLP, they have decided to withdraw it. Lordship will kindly see that order at page 179, page 194. Learned counsels appearing for the petitioners seek permission to withdraw this SLP's permission is granted. So when it was about to be decided, they decided to. My friend was watching. So this is the position. One is that for 20 long months, they were in slumber, and there is a unpardonable delay on their part in approaching this court. We are ready with the result. Maybe in next 2 or 3 days, we are going to announce the result. Number one. Number two, in spite of knowing that the corrigendum which is put to challenge now of 15 March 2024, they decided to participate in the recruitment process, saying that they are eligible, but on verification, it was found that they were not eligible. They took up that issue before the learned single judge, before the division bench. They went up to the Supreme Court. There was no relief to them. Now they have explored a new ground. What is the new ground? That this corrigendum was issued, and it was not put to challenge. Who stopped them from challenging it at that appropriate point of time? It was their default. They are at fault. So now one additional ground they want to raise. I have no objection to them. What they are saying, they are submitted an application with 11/11/2025 representation, and there are 2 dates, one 2024, one 2025. I have to verify. Now, from where this has cropped up? Lordship knows how the system works. To make out a case, one document is enough. So these documents, why they have not placed it before the learned single judge in the earlier 3 rounds of litigation? So in my humble submission, this is the afterthought. After getting no relief from any of the 3 forums, learned single judge, the division bench, and the Supreme Court, they, in my humble submission, we have reasons to believe that they have manufactured this document. If they had this document, because the council has submitted that they earlier approached this honorable court, same petition. So if these same petitioners are having that document that a particular application was submitted, they should have placed it at the earlier time. They have not done it. So they want to have a fresh channel of cases now. Single bench, division bench, Supreme. But for that, I have no objection, because we have to fight the litigation. The government has no difficulty in fighting the litigation in a forum. But the only thing is that the prayer that 15 posts may be kept vacant. In my humble submission, it may not be passed, because prima facie there is no case at all. If they have to get any relief at the interim stage, then they have to satisfy the court that they were prudent, they acted on time, they have come with clean hands, and on top of that, they have a very good ground on merit and on law. Then only the honorable court, by applying the 3 golden principles, will give them a benefit. That the balance of confidence is in their favor. Irreparable loss will be done to them if it is not granted. And there should be a prima facie satisfaction. So, and the judgment which they are relying, page 156, it has already fallen from Lordship's count. The guidelines framed by the Supreme Court, the direct, page 156. We therefore answer the reference the following terms. Recruitment process commences from the issuance of the advertisement calling for applications and ends with the filling up the vacancy. Our recruitment process started on 26/12/2023. It was not complete on the first day. The advertisement was incomplete. Two major things were not notified. And there is a specific and categorical averment the advertisement itself that in future we will notify the exact vacancies, category of post, etc. and the date of application. Number one. Number two, how to apply has not been given there. So without that, nobody can apply. The window was open much later. Thereafter, when this advertisement was issued, after 4 months, one clause has been removed, and that clause will not help them. The clause which they are reading that it may dilute. Can we dilute it now? Eligibility criteria. No government can do it because there are thousands of cases of the division bench at the Supreme Court that we cannot dilute the recruitment process. So that is number two. That means on 28th of November 2024, we have to give up the requirement of B.Ed. Without B.Ed, we are going for the recruitment. That question we have to place ourselves. We cannot do that. Three courts have said that on the last date of submission of application, you must acquire all your eligibility criteria. So, 3. And this judgment in conclusion, paragraph 42, Roman 1, the one says, recruitment process commences from the issuance of the advertisement. We have no quarrel with this proposition calling for applications and end for. So, calling for application to be started by, we have not said when it will be accepted, when the application will be accepted, and how to apply. There can be offline application. Hold on. In our addendum of 15 October 2024, we say how to apply. So next paragraph, number 2, 42.2 says, eligibility criteria for being placed in the select list notified by the commencement of the recruitment process cannot be changed midway through the recruitment process unless the accent rule so permit, or the advertisement which is not contrary to the accent rule so permit. Even if such change is permissible under the accent rules of the advertisement, the changes would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitration. So, if we are changing the conditions of recruitment, page 77, conditions of recruitment, we cannot change according to the judgment which my learned friend is relying and make it a part of the record. We are not changing conditions of recruitment. What we have changed is, Lordship will come to page 82 F. That is, please note, page 82 down below, there are certain SOP type instructions. One instruction has been withdrawn. So this is not a recruitment condition or conditions of recruitment. So the Honorable Supreme Court, I am relying upon their judgment now, that we are not touching or not diluting or not tinkering with the recruitment condition or eligibility condition. In fact, we are firmly standing on our position that there cannot be any relaxation of the recruitment conditions or eligibility conditions. So in my humble submission, Lordship, no prima facie case has been placed before this Honorable Court, and there is no reason to pass any interim order, because otherwise these 15 candidates who are otherwise getting the appointment order now, they will be deprived. They had their B.Ed degree on 28th of November 2024. Why should they be deprived? And these people will also not get deprived. Every year vacancies start. Every year we accumulate, because this is initially why we did not have the notified vacancy number. Now it is about 8,000 posts. That was in 2023. We are completing the recruitment process now. Our intention was to do it in 2024. But subsequent all these vacancies, we cannot consider those vacancies. In 2024 also, there are a lot number of vacancies arising. 2024 also arises. those vacancies are still there. Those will not be filled up. So in the next round of recruitment process, they are eligible. It is not that by not giving any relief, they will be deprived of their career, because they are, I think, several times figured that whole career will be doomed. It's not like that. Today, if I am not graduate, I don't get the, if I don't have the LLB degree, I don't have the license. The day I will have the degree, then I will get the license. Before time, it cannot be issued. Lot of LLB students give their examinations in the month of July. Their results are declared in February or March. Are they given the license in the month of October? This is what they are asking. So once you get the license, so to get the license, you have to fulfill all your eligibility criteria, and they have already miserably failed in all the other forums while trying to urge that down. That I was not having, and blaming this institute, that Calcutta, that they have defaulted in giving the results on time. I don't think that can be. And they should have come on time. There is a major delay, and that delay is fatal in my humble opinion. In fact, Lordship may not be pleased to issue notice of it. For that purpose, I am taking to judgment on delay and laches, as well as on the principles of equity. Acquiescence is that they have already acted upon the advertisement. Once you have participated, it cannot be said that you have participated, you have failed, now you can raise objection. So they have so on the ground of delay, Lordship would kindly take this Supreme Court judgment. Chennai Metropolitan Water Supply and Sewerage, there are a series of cases. Actually, it's a very fundamental. I normally don't face all these judgments. It was decided in 2024, paragraph 16. Thus, the doctrine of delay and laches should not be lightly brushed aside. A writ court is required to weigh the explanation offered and the acceptability of the same. The court should bear in mind that it is in exercising an extraordinary and equitable jurisdiction. As a constitutional court, it has a duty to protect the rights of the citizens, but simultaneously it is to keep itself alive to the primary principle. When an aggrieved person, without adequate reasons, approaches the court at his own leisure and pleasure, the court would be under legal obligation to scrutinize whether the lease at a belated stage should be entertained or not. Be it noted, delay comes in the way of equity. In certain circumstances, delay and laches may not be fatal, but in most circumstances, inordinate delay would not only invite disaster for the litigant who knocks the doors of the court. Delay reflects inactivity and inaction on the part of the litigant, a litigant who has forgotten the basic norm. Namely, procrastination is the greatest thief of time, and secondly, law does not permit one to sleep and rise like a phoenix. Delay does not bring in hazard and causes injury to the least. In the case in hand, though there has been 4 years delay in approaching the court, yet the lead court choose not to address the same. So the principle is very clear. If they are really aggrieved by the order of corrigendum, which was issued in the month of March 2024, 20 months ago, they should have immediately challenged it. Now, at the back end, the 11th hour, when the appointment orders are ready, they have come. And they have also submitted to that corrigendum. How? By applying and participating in the recruitment process. They went to the verification stage. They appeared before the authorities with their documents, and the documents, when placed, it was found that there is an infirmity, and therefore their applications or their candidatures were rejected. And against that, they came to the court with various grounds. Even this ground was, my friend is saying that he is maybe verbally someone has argued on this point, but nobody has challenged that for it. So this is the first thing. But that does not allow them to raise this issue at this again when the whole recruitment process is going to be over. And if Lordship direct that we should dispose of the application, you will gladly do it, provided they have actually submitted the application, or else Lordship can direct them with the order of this court that this application is submitted now, and we'll take it on. We'll pass a speaking order if they are happy with it. But otherwise, we cannot dilute the condition fulfillment of recruitment conditions on the last date of application. That is the Supreme Court also. It's the same act, the same petition. So, completely opposite.
I just need 5 minutes. Yes,
Okay.
I need 5 minutes to respond, my lord, on all these aspects. 5 minutes. But first and the foremost thing that has been argued is delay, my lord. And my lord would kindly note that for a writ petition, specifically when I am asking non-consideration of my representation, it has not been considered even till today. I have the acknowledgement number also of the representation. So the fact that my representation has not been considered till today, it is actually the government who needs to explain as to why for a period of 1 year they have not considered my representation. I understand the writ petition was served to them 3 days prior. They could have taken instructions on the fact that what happened to my representation. Was it received? Was it not received? Was it dismissed? Was it accepted? Whatever may have been the case, that is not something that has been argued today. Assuming against myself, though the law is clear that for a writ petition, violation of fundamental or constitutional right, there is no limitation. Assuming arguing against myself, that there is some limitation for a minute that the learned AG said needs to be considered, then, my lord, it will fall under Article 137 of the Limitation Act. Under Article 137 of the Limitation Act, which says that if there is no limitation provided for a writ petition that is challenging an order, the limitation will be 3 years. That is what Article 137 says. So, arguing against myself also that assuming whatever the learned AG is saying is correct, even then the limitation is 3 years, because under the Limitation Act, for filing a writ petition challenging a government's order, there is no limitation provided. At the same time, my lord, my cause of action exists even today because my representation has admittedly not been decided. That's very, very important as my submission. That's point number 1. Point number 2, my lord, it was argued on behalf of the government that because I have participated in the recruitment process, I have waived off my right to challenge it. This, my lord, if my lord would want, I will make a compilation and I will give those judgments to the learned court master. But my lord may kindly note down 3 judgments which of Honorable Supreme Court are directly on this point, that waiver/estoppel, when there is a challenge to an order of the government, will not come in my way even if I have participated. Kindly just note down 3 citations. I will make a compilation and give it if my lord would want to consider that point. The first citation is, my lord, 2019 20 SCC 17. 2019 20 SCC 17, at para 17, the Honorable Supreme Court says that the rule of estoppel is not applicable in cases where the procedure is vitiated on account of illegality and misconstruction of statutory rules, and that the candidates, by agreeing to participate in a selection process, only accepts prescribed procedure and not the illegality in it. Exactly on point. This, my lord, has been again followed by the Honorable Supreme Court in 2 more judgments. I am just giving the citation. I will make that compilation and tender it. The second judgment is 2024 7 SCC 262 at para 36. And the third, my lord, is 2024, that comes from the High Court of Manipur, my lord. It is a Supreme Court judgment. 2024 SCC online SC 2316. This is para 32.
What is the page number?
S 2316, my lord. I'm sorry. 2316 at para 32. All these 3 judgments, my lord, of the Honorable Supreme Court in one tone say that mere participation in a process does not mean that I have accepted the illegality. And all these, my lord, were cases where after participating, the candidate has challenged the illegality so-called in that particular recruitment process. Point number 3, my lord, kindly come to the SLP withdrawal order, which the learned AG with confidence said that they had observed, etc., etc. But one thing which has not been pointed out to my lord is, at page 193, kindly see the SLP withdrawal order. My lord would have 193.
Yes.
My lord would see for respondents, the appearance is 0. There is no one who has appeared for the respondents. At 193 bottom, my lord would see for respondents, there is no one. 193 bottom. There is no person appearing for the respondents. But for the petitioners, there is a group of number of counsel. The first counsel, that is myself, my lord, I had assisted the Honorable Supreme Court in the very same matter. It is a simpliciter withdrawal, my lord. It is not a withdrawal after consideration on merits. I say this with responsibility. For this reason, the only question that the Honorable Supreme Court had put to me, because I had appeared, I had argued this matter, and therefore I'm saying it with responsibility, not saying that I observed the proceedings, is that because there is a relaxation given under the rules, was a representation moved? This was the only question the Honorable Supreme Court had put to me. And I said that yes, a representation was moved, but it was not a part of the record in the previous litigation. Therefore, the Honorable Supreme Court in this hearing suggested that now you withdraw and argue on the representation. Because, my lord, arguing against myself for a minute, whatever the corrigendum may say or not say, the rule is in existence, the rule has not been amended, withdrawn, etc. The government is concerned and governed by the rules of recruitment. I have given a representation which is in consonance with the rules. The rule has not been amended till today. So therefore, my lord, the government was duty bound to decide my representation. Whether positive, negative, that's their call. So therefore, my lord, when this hearing came up, it was simpliciter on the point, and I'm saying this with responsibility because I had the occasion of assisting the Honorable Supreme Court in this very matter, that when there is a representation and when there is a rule, our argument should be simpliciter on that invoking the rule, I'm sorry, my lord. On the basis of representation, I should have invoked the rule and I should have fought on it. Therefore, it was withdrawn, my lord. Otherwise, the Honorable Supreme Court would have noted that we are not inclined to issue notice, therefore it is withdrawn, which they usually do. But it is not, there is no observation on terms of merit in this very order. My lord would see at 194. Learned counsel appearing for the petitioner seeks permission to withdraw these SLPs. Usually when we argue and then it is withdrawn, my lord, the Honorable Supreme Court, I will produce 100 orders a day which say that after arguing for some time, the learned counsel wishes to withdraw. That is not the case here. Whenever we argue and the Honorable Supreme Court is not convinced and they want to dismiss, then the observation which will come in the order is after arguing for some time, he seeks permission to withdraw. But that is not the observation here. The observation simply is learned counsel for the petitioner seeks to withdraw. The reason is because the question and the answer that happened during the hearing, which is about a month ago, was only on the point of rules and the eligibility. That if there is a rule and there is a representation, please fight out on that. Therefore, in fairness, the first thing I said, there was a previous round, but this corrigendum and this fact of representation was never argued. Then the fourth point, my lord, very, very important. What has been argued throughout is that there is a date by which these documents had to be given. And I am grateful for that argument because as per the advertisement and as per the rules, I will show that the documents that had to be given were only at the verification process. They were not to be given at the time of filing the application. This is very, very important. The application had to be filed by 20th of November 24. The verification took place only in May of 25, 6-7 months later. And when the verification took place, I had all the documents. I am not seeking a relaxation in terms of eligibility. Kindly see that 2 clauses of the advertisement with me, which say that the documents that are to be given are only at the time of verification of the physical document. They do not have to be given at the time of allowing. Please see. Kindly see 87, Lord. 87, number 10. 77 number 10, when the candidates appear for verification of documents, they must produce original certificates, testimonials and documents that were uploaded during the application stage. And it is admitted case of everyone that when the application was made, it is only the particulars they ask for. They don't ask for any documents to be uploaded. That is an admitted fact on record. I don't have to upload A document, B document, C document at the time of applying. It is only when I go and give my documents for verification, that time the original is to be taken. That's very, very important, and that has been missed. And fourth most important thing, my lord, usually, because there are three categories of advertisement. The first category of advertisement will say that the cutoff date, you have to be eligible as on the day of advertisement. The second category of advertisement will say that you have to be eligible as on the last date of the advertisement. The third category is that when the advertisement is silent. Please see the rules. The rules are silent on the fact that as on which date should the course be completed. The rules are absolutely silent. Just see that with me for a minute, my lord. The rules govern the eligibility at page 36. Because ultimately everything falls on the rules. The rules at page 36 talk about the academic and professional qualification. This is regarding teachers. Page 36, my lord, would have clause 10.1, rule 10.1, I'm sorry. The academic and professional qualification for direct recruitment shall be as in schedule 3. In addition to so-and-so, so-and-so, so-and-so. Schedule 3, my lord, would find at page 55, bottom. 55, bottom. Bottom is important, schedule 3. It says for postgraduate teachers with at least 50% of marks from recognized university and Bachelor of Education from so-and-so, but degrees obtained off campus so-and-so shall not be considered as valid. Now, when do we need to obtain this? Is silent. The rule is completely silent. I read again. For graduate teachers, graduate/postgraduate from recognized university with at least 50% marks in their graduation or post-graduation and Bachelor of Education from so-and-so recognized institution, but degrees obtained from so-and-so shall not be considered as valid. Distance education. This is not a distance education case. The question really is that what is the cutoff date? Should I have this degree by the date of document verification when I actually need to produce, or should it be on the last date of verification? The rules are absolutely...
But it is in the advertisement itself.
It is not, my lord. I will just show that the advertisement also. Kindly come. What was being stated is not right. The advertisement does not say. Kindly see page 77. Kindly see 77. I'm grateful for that question, my lord. I will show that in the advertisement there is nothing mentioned as to when should the documents be available with you. Kindly see page 77. Minimum educational qualification. This is bottom of the page. Kindly see. I am hit by 2, subclause 2 for the post of graduate teachers. The candidates must be science graduate or postgraduate in science having from recognized university with at least 50% marks in either graduation or post-graduation and B.Ed from NCT, National Council of Teachers Educational recognized institution.
You were referring to page number?
77, I'm sorry, my lord. 77.
So you come to page number 95.
Indeed, my lord.
Condition for recruitment.
Indeed, my lord.
Yes, condition for recruitment, point number 1.
The applicant must be a postgraduate in concerned subject with at least 50% marks or equivalent from so-and-so from an institution as recognized by NCT. This is exactly taken from the rules, my lord. But when is not mentioned here. The cutoff date, what we call.
It becomes clear that on the date of advertisement, you must have the requisite qualification.
Yes, my lord, I will just directly answer that because I had the occasion of dealing a similar matter with respect to West Bengal before the Honorable Supreme Court. I will place that judgment on record. My lord, usually the advertisement will say that by the last date of advertisement, as I said, there are 3 classes. First class is that by the date of the advertisement, one should have taken the qualification. That is the first class. The Honorable Supreme Court discussed. I will produce that judgment. Soman Paul versus State of West Bengal. It is a 2025 judgment, recent judgment, my lord. Kindly bear with me for 1 minute. There, what has been described by the Honorable Supreme Court is that for advertisement, there are 3 classes. The first class is where the advertisement itself says that the cutoff date for eligibility will be as on the date of the advertisement, which is not the present case. Here, there is no clause which says that you should have acquired the minimum eligibility as on the date of the advertisement. The advertisement is silent about that. The second category of advertisements are where they say that one should have acquired the eligibility, minimum eligibility by the last date of the advertisement. That is also silent here. The third class is where both these things do not come, then we have to go as per the rules. The rules are also silent that as per which date, because there has to be a date by which I need to give my documents. Rather, my lord, that one line that I had read about when do I need to give these documents, it is only at the stage of document verification. Because this is a long process, my lord. First process is application. The second process is a TET examination. The third process is document verification. And the fourth step in the process is to give me appointment.
Okay, all right. You produce those judgments you have relied upon by afternoon today?
Yes, very well. I will produce it, my lord. By 2:30,
Yeah.
I will produce those judgments.
Yeah.
One last thing, if I can show, my lord, there was a question put to me. Can I just answer that at page 114? At page 114, there were two parts, my lord, of the corrigendum.
Yes.
My lord would see the third line of the first part, reservation criteria clauses for EWS category. The first part at page 114 says that it is respect to EWS category. But I am not concerned about EWS category in any manner. So therefore, my challenge is to the entire corrigendum because the first part doesn't affect me. I am challenging the entire corrigendum because it is against the rules. I understand if the state would have amended the rule of relaxation, saying that we are withdrawing the power of relaxation, therefore we are taking out this clause from the advertisement. Yes, state was right. But here is a case where there is a rule which persists, the rule exists. But the advertisement is contrary to the rules after a specific date. And one last thing I wanted to show, my lord, on the aspect of delay, because that was really highlighted, it was not really on merit, my lord. Kindly see the date sheet for a minute. The date sheet is very, very important. Kindly have the date sheet. Just one last thing I wanted to show. Please see the date sheet at page 196. 196.
Yes.
My lord would have that this date sheet has been issued by the registrar. On the right side bottom, the date is mentioned. That is 5th August 24. The date sheet that has been mentioned has the signature of the registrar who is issuing the date sheet. The date is 5th August 24. On 5th August 24, the registrar of the university says that by November 2nd week, I will pronounce the results.
Okay, all right.
That interim protection, my lord, may kindly consider.
We'll examine the issue. You produce those judgments you have relied upon.
Very
We'll
well.
pass the order. We'll upload it tomorrow.
Very well. My lord, may kindly consider the interim protection, my lord.
We'll see.
I'm so grateful, my lord.
We'll resume after 5.
I'm so grateful, my lord.
Okay, just 1 minute.
Yeah.
Okay.
Yes, just one thing I wanted to say, my lord. Lord, that representation, a lot of doubt was raised. Can my lord hear me?
Yes.
My lord, the representation receipt number I have fetched out, receipt number, that is 11238. That is the receiving number of 11/11/24 as per the office note. It is 11238 as per the office record of the government. That is something I wanted to give, my lord. We'll put it along with the copy of the compilation. The receiving number of at the diary entry which is done in the office, that is 11238, dated 11/11/24.
Okay, all right.
That is the only thing, my lord. I'm so grateful, my lord. I'm sorry for it.
Your lordship has already made this
You have completed your argument?
Yes, Your Lordship, almost it was completed, but I would like to mention one thing.
Yeah.
That they are saying that school is not a research school and it is only a tea garden management school. But the fact is, Your Lordship, tea garden, even it could have been managed by tea garden. But if it does not fulfill the criteria to be provincialized under the Provincialization Act of 2017, the schools cannot be provincialized. And Your Lordship, the present school is provincialized only under this act. And therefore, I would like to present this act before Your Lordship to consider kindly Section 3X of this act and Section 21 and Section 30.
Okay. Yes.
Paragraph 7.
Paragraph number 7. Yes.
Further dictated that the reported that principles of after some the similar stated that government has set the degree reported they have they
No, where it is stated?
paragraph 7 the second paragraph the business further dictated under the reported process that was not prohibited. Therefore, there comes the similar stated that good government has set the degree provision of Act to elect. It means that there is there is there's 2008, 2007 there is not the there is it takes our
Page number? Yes.
secretary to the Department of Assam to the Education. The public interest, the academic interest of the the Department of Education is please provincialize. Now they are going to provincialize number of 490 numbers of tea garden food LP food, two tea garden food and one tea garden as per the food and herewith as answer A with the condition that services of the is by the garden medicine will not prohibit. However, the teachers can continue to serve the same food under the payroll of the concerned tea garden as their services. They will serve, serve their same serve the same food under the payroll of the under the next matter in this connection post of the church of the 400 school, three post of teacher of the school, the post of 501 headmaster of the high school is created. The student of the professor will get the benefit of the check and program midday meal, free uniform, etc. The recruitment of teachers will be done at the those professors there will be
And that is why still there is no fresh recruitment. Only 2 teachers are deputed. Still there.
Therefore, you get the
the concern
Father David ensured a happiness with the better academic potential. The teacher is by garden authority will also bring various facilities like of the teachers the gifting program organized by the Department of for of other the business protected the not paid the legacy of the case it
Eight,
it
80, 80, 80.
it
Not affidavit.
our
What you first they have filed on 9th, but they place the document. Start with the affidavit. Paragraph number 940. Paragraph number 3. Paragraph number
that the report stated that fight stated it would another number that a government of Assam is the academic research regarding the the department of regarding that the post of teachers of the 400 the report further stated that this was working as exactly center center under the SS in Assam, which is temporary and was not working as a teacher in the state. As per the report of the DO Dibrugarh, the state SSK center was closed in 2014. Further stated that there was no professionalization of teacher of regarded goods. Moreover, the teacher was not working as a teacher, so the claim of the teacher
yes. What is your argument? Your affidavit is the page number. 7 or 8. 7, respect number 7 management. Page number. Yes. Sir, we have also filed our affidavit. My submission is comes up. The school. No, you tell me your page number. Yes. I filed the affidavit on 6th of September 2024. I respondent number 8. Affidavit I filed 6/9/2024, Lordship. Yes. Page number 86. Yes, Lordship. Okay. And prior to that, Lordship, I have also filed one affidavit that is on 20 flag F 28/3/2024. So before coming to the affidavit, Lordship, the thing is that the school is run by the management. Only 2 teachers were appointed to the government. So
he is not under that, the petitioner is not under that temporarily appointed teacher. And only 2 teachers are temporarily deployed by the government. This is solely run by the management. The question was raised before the Honorable Court on 22/4/2024 regarding the maintainability of the petition, because the management is run so that this petition not maintainable. Then Lordship kindly come to the order dated 22/4/2024. On the day, Honorable Justice Kanundi, 22/4/2024. None appears for the petitioner on call. Applicable Learned Council, Elementary Education Department has placed on record the instruction as received by him from the Director Elementary Education, which reveals the school of the petitioner was provincialized by right so and so. However, it is contained in the state instruction that petitioner he is not entitled to being considered for provincialization of his service, as he was working as a Shiksha Karmi under particular scheme, not a teacher of the state school. However, in the absence of the council, the council court would not like to further consider issue according list the matter so and so, copies of the communication dated so and so were marked as X and Y. So for that, they have submitted the affidavit in 2025. Then Lordship on 3/5/2024 order. Then 3/5/2000 as Sharma Learned Council for the in view of the stance taken by the present proceeding, phase so and so, it is now required to satisfy this court as to whether the present petition being with regard to grievances raised against the tea garden would be maintainable. So that question must come up before the Supreme Court to satisfy her. And he has failed to that part. Now, the government has also submitted their affidavit, wherein the petition is not, the school is not actually the provincialized, though they are the school is provincialized, because in provincialized, but everything is managed by the government. But in this school, only 2 teachers, that is your Lordship. Now I have my affidavit come 23/8/2024, flag F. Page number 64. Flag F on 28/3/2024. Because the petitioner was appointed not by any interview or any written test. As such, all other associations started objecting only on the recommendation of the Labour Commissioner, Assistant Labour Commissioner. So, let's see, page number 64. Flag F, page number 64.
Annexure C.
Annexure C. With reference to subject item above, I have honor to state that Bibura LPS is a provincialized school, so and so. The teachers engaged by tea garden management are not provincialized. The present state of Burba TVC is active with enrollment number so and so. And we are also there in page number 65. Also come. The annexure D.
Yes.
In the interest of the public service and for academic development, the student tea garden management school provincially by so and so under deployed district, the following teachers are temporarily deployed to work PGMS school shown as in two numbers, column number 2. One is B. Barua is reported to Meghali Devi.
Serial number,
Serial number 2. Dibrugarh, Barbarua TLPS school. So one name is Meghali Devi. And another two in the bottom, 66 2. 66 in the bottom it comes up. The teachers are deployed temporarily in the school. So the lists are as given here, where her name is not reflected. Cannot claim that she is the provincialized teacher, whatever. She appointed a Shiksha Karmi earlier. And in the school, what happened here? In the read petition level comes up, he was given appointment earlier this. Now they come to the read petition here. Next, sir, page number 17 of the read petition.
page number,
Page number 17 and Lecture 4 of the read petition. How she got the appointment to the manager. Lecture 4, page number 7.
yes,
To the manager, Barbarua teacher Dibrugarh forwarding prayer petition Abhishek Kalindi regarding continuance of his service so and so. With reference subject title, I have including here with a letter received from Avinash Kalindi regarding continuance of service as a school teacher so and so. As per your letter so and so, you have been kept in abeyance of appointment with further no objection. So some workers are apprehending law and order situation. The management have not initiated any further step to resolve the issue after issuing order negligence in service viewed seriously. That was the only. The reason now you're in her read petition is typically stated that her appointment was not on the basis of any interview or written test. So the large association were come up and the whole entire situation was disturbed. Then management under compulsion terminated because it has into nothing was it. Here the petition is claiming that she is to provincialize. She is provincialized. So there is not such a document that he is able to prove that through elementary education officer he has been appointed. So that's why the Lordship at that time in 3-5 order the director acts as why notifications were counted and asked her whether it is maintainable or not. And our High Court, so many decisions are there when the school is run by the management. This is your Gugoi and others. Para 20. So here there is not such a document to prove that the school is provincialized and the present read petition is maintainable. If there is any grievance, paragraph 20. In the case of committee management, Delhi Public School so and so, Apexo held that no writ is maintainable against a private school as it is not a state within the meaning of Article 12 of the Constitution. In the case of so and so, reported so and so, Apex Court upheld the view of Division Bench Patna High Court, which has held that teachers of privately managed school, even though financially aided by the state government or the board, can not maintain a writ petition against the order of termination from the service passed by the management committee. In the case of Satyabala Sharma so and so, reporting that Apexo held that unaided private minority schools over which the government has no administrative control.
okay,
So this is here in the case is the same. If he claims that management appointed her. That's only on the recommendation. There is no, when the registration starts, then the restriction mentioned. No interview, no, so many gatherings, so many problems, the chaotic situation arose. So and then we have to terminate it. So interview, they have only claimed that without interview, without written test, how can it come? So she is not that she is a provincialized claiming the under Section 2 that education authority through his approach. No, when this thing is managed, when everything is by the management, for their safety, they tend to, if any grievance, they can approach the civil court. The writ petition is not maintainable. Because he can place any such document that he is genuine every part. First part here, he is done in the prayer process, so he is claiming everything through the education department. But on the 22/4/2024, he failed the X and Y document. Then court asked her to file affidavit. Then they have filed. These will provincial. In repeated themselves said that school is not provincialized. Definitely, school is not provincialized. So two ways she is trying her case in any way. If the everything is mentioned, just a chaotic situation. Her appointment was through government. Any document, no in the writ. Not a single document. Then court eliminated education does X and Y document is annexed. That is clear. How the writ court then C5 so they given ample opportunity them to produce the document. Then BOD has also furnished the document. On both, we are saying the school is managed by the government, has no any interference. Only two teachers. And she is claiming on among the two teachers. If she has any document in place, government will have, we have no any objection. How the government has appointed. So that's the petition itself is not maintainable.
Make this journal.
Yes.
You're not how their features and defend you wrong. I list the annexure 1 of my petition. This is the certificate given by the headmaster of their school that I have been working since 2007. Then come to annexure 2, your lordship. That is my salary structure. What type of salary, how much of amount I should be given. That is annexure 2. Then come to your lordship annexure 3. That is also about my appointment. Then come to annexure 4, your lordship. That is the letter by Assistant Labour Commissioner Dibrugarh to their school to consider why my service was kept in abeyance. Merely the apprehension that there will be agitation against me, they kept my service in abeyance without giving me any opportunity, any notice of being heard. And if there was such a situation, why they didn't file an FIR before the police station? No such document have ever been faced by them, your lordship. Only some mere apprehension that there will be agitation against the garden, so they kept my service in abeyance. And so far, there be again and again that the school is not provincialized. The RTI report itself reveals that the school is provincialized. And the RTI reports have been placed before your lordship not only by me, but even by them also. That page number 59 of their own affidavit in reply, they have conveyed the 59 your lordship that with reference to the subject cited above, I have the honor to state that Borpura LP school is provincialized school. High government notification is and the teachers engaged by Tea Garden management are not provincial. The present status of Borpura LP school is active with enrollment 198 government deployed 2 teachers, TV teacher 5. And why the 2 number of teachers, that is also to be looked into, your lordship, because as per the Government Provincialization Act, Section 3 Act states that at least 2 teachers have to be appointed by government as provincialized teachers. And your lordship, as my service was kept in abeyance, I could not submit my documents for consideration before the DLC for the purpose of provincialization, your lordship. Kindly see annexure 6 of my petition, your lordship, that is a letter Deputy Secretary to the Government of Assam inviting a response to the government OM quoted above, I am directed to say that Section 13 of the Assam Education Provincialization of Practices of Schools and Reorganization of Educational Institutions Act 2017 provides for a direct scrutiny committee in each district to scrutinize service reports and other related issues of the serving teachers of cancer educational institutions pertaining to provincialization of their services, Your Lordship. It's true that my service is not provincialized because I could not avail the opportunity because my service was kept in APM. And in view of the above, you are requested to submit the report of the District Scrutiny Committee in the enclosed format as next one.
Madam, the answer to is purport. Put by the tea garden authority.
Yes, management is by them, Your Lordship.
Yeah.
It's a cancer school, but management could be by them. And as it is a venture school, that's why it is provincialized under the Provincialization Act of 2020. The services of teachers are to be provincial. And as of now, deployed, not liquidated.
No, that right. Sir, against the tea garden authority.
It's maintainable, Your Lordship. Because ultimately, the differences are not same as and it completely becomes a government matter. Because it is the government authority which will scrutinize whether
No,
my
no,
services
school is being run by the tea garden authority.
it's tea garden management authority. Okay. Central school management is by tea garden. But the services of two teachers could be provincial. And that's why government deployed two teachers, Your Lordship. And that is in the RTI report also. The government deployed teachers 2 and PG teacher 5. Otherwise, why the government would have deployed, Your Lordship? If it is only a tea garden management school, nothing to do with venture and provincialization, then why the government would have deployed 2 numbers of teachers?
Where is the order of
Which order?
deployment of two teachers?
This, Your Lordship, their own annexure, page number 59 of their affidavit in reply. Page number 59, annexure C.
Their affidavit of response number 8. Annexer,
Annexure C, Your Lordship, page number 59 of their affidavit in reply.
Yes.
That with reference to the subject cited above, I have the honor to state that Forward TELQ school is a provincial school. High government notification. Latest so and so. The teachers engaged by tea garden management are not provincial like. The present status of Forward TU school is active. With enrollment 198, government deployed teachers 2 and PG teacher 5. And you will also kindly see section 3 Act of the
okay. Yes, madam, what is this? Answer C, page number 6. Oh, page number If the school is provincialized, whether the person working there are not supposed to be person. No, that's all right, but if the school is provincialized, then the definition is maintained. No, the Sharma has argued on the point of maintainability. If the school is provincialized, then why this petition will not be maintained?
That is, see, actually, what is specific here carried out? See, the notification, budget notification, I marked it the provincialized definition. School, when the school is provincialized, everything is taken up by the government. So here only 2 teachers are. Rest management, everything is banned. That's why our High Court decision is there. Various category decisions and there's also one decision of the Supreme Court also. Now they are submitting before because that's why Protocol 4 takes the matter for maintainability because on both hands here it comes up. Salary is paying by management. Our appointment was through assistant level commissioner, not through the director level education officer. On the only recommendation, then the education was start very properly because no interview, no written test. Then we under compulsion we have stopped and kept in abeyance because so many problems there. Very few organizations were come up. How they put it. So that was
No, where is the provincialization order?
that is what government will place for the court. By PDP they have placed that these are just only the 2 teachers are. And the school is provincialized, that definition needs to be clear for the when the provincialized says that everything is done by the government. Something is regarding the material
Your
how
lordship,
these things are
2 teachers.
One by one. Page number?
Our
Page number?
start
Yes.
the first paragraph. Not 4 line. Garden managed by figured going prohibited on the consider service of the executor is by the third will not prohibit. However, teacher can continue to serve the input under the pay role of the concerned figure.
Paragraph number 3.
First paragraph. The public interest and academic interest of the
Your page number 99 is your evidence.
page number 9. Our page of 9 on secretary on
Yes.
the first paragraph the public interest academic interest of the third number of 400 of garden is at the school, numbers of garden one garden is high school as per the school annex here A and B with the condition the service of the executor engaged by the tea garden management will not prohibit. However, it is continue servicing under the pay of the concerned garden as on the zero
May I put yes. Only and this is we will find the annexure 5 of my petition. There will find your lordship that this amendment documents from the eligible candidates of those venture schools whose services would be considered for the purposes of provincialization, Your Lordship. And Section 21 of the Act clearly states that the provincialized post will be personal to the incumbent. Once the person dies or ceases to retire, the post will disappear. Because the services are only to be provincialized. And that will clarify the doubt, Your Lordship. Not the whole school is provincial. The post of the teachers will be provincial. And as of now, there is no two such provincial teachers. The government is compelled to deploy two numbers of teachers. And I am not given the opportunity to submit the documents before the TLC to scrutinize whether I am eligible for the purpose of provincialization of my services or not. Because as per the Act, these school teachers can submit their service reports for the purpose of assessment of provincialization. But that time,
Madam, you see one thing, certificate was on basis of
yes, prior to that, the school was provincial, and the government later was the school was central school, Your Lordship. And
no,
the government notification.
no, Madam, see, is there any doubt regarding this notification by which the was provincialized?
No, Your Lordship.
No doubt.
No doubt. But the thing,
So this provincialization came into effect with the issuance of this notification on 18th of April 2023.
yes, Your Lordship.
Right.
It was only,
But you have filed this petition in the year 2020.
yes, Your Lordship. Because,
So on that day, this notification was not there.
yes, Your Lordship, but the government notification was there, seeking the documents from the teachers of the venture school. And my school is a venture school. Your
Maybe,
Lordship.
but
My school is other, if not, it would have been a
Guidance
venture
would
school.
not-
How this could be provincialized, Your Lordship? If it was not a venture school, how it could be provincialized? Because the Provincialization Act of 2017, laying down the criteria which schools are eligible for the purposes of provincialization, how many teachers can submit reports for the purpose of provincialization of the services. The
no,
venture
that's
school,
all right. But provincialization came to effect from 18th of April 2023. To file this application, petition on pardon, 2020.
this act is, Your Lordship, for the venture school. This government act, the act that has been 2017 act is for the venture school, Your Lordship. And that's why my petition is very much necessary. This is for the venture school teachers, Your Lordship, who are given the opportunity to submit their documents. Your Lordship. That is for the venture school. Also, it stated that it is for the provincial school. These both are different, and why this school is provincial. And the management would be by disregarding, Your Lordship. But if it does not fulfill the
No,
requirement of the
at the time of filing this petition, it was done by the management.
management, Your Lordship, but it's a venture school. Otherwise, it would not have been provincialized. Because the act itself lays down that the criteria which a venture school can be provincial. And as the poverty state,
That's all right, but it was not the founder teacher of that.
I'm not the founder teacher, but
It
have been
was founded by the
regarded.
management.
After all, it is a venture school. The management could be by regard, but it's a venture school. Because it has the midday programs by government. It follows the government rules and regulations, and midday programs are also going on in the school, Your Lordship. And there are many.
No. Whether at that point of time midday meal was given to the
Yes, Your Lordship, and even the that is Guru Shafts are also helped. I have some documents, Your Lordship. Kunut stocks are also held in the school.
Pardon?
Kunut stocks, Your Lordship. Kunut stocks is government.
So whether those documents are part of the record.
Or it is not a census for Your Lordship, it is not eligible for provision. It must be a census, then only it is eligible for provision. And that is for the basic institution only. I am seeking the opportunity.
Can you do one thing? Take record by you bring it on record by filing that
What I did.
they give you 1 week time
Okay.
or or 4 and 6 or for respondent number 5 and 7. Therefore, 1 and 3. Heard in court, list the matter after 1 week.
Lordship, kindly a date may be given.
So as to have heard it, take record by filing an
Yes, yes, yes.
27 November.
27, 20, 26,
28 November
28 to nothing.
and 1st December.
May I please, your Lord. Lordship, I am sorry to mention at this hour, my Lord. So item number 9, my Lord, Senior English Counsel, Mr. Indian Suri has left the court for some urgent work. It needs to
Okay.
taken up on, my Lord.
after
Item 9.
the prayer being made by Mr.
As Hazurika.
Authority or
16 or
You-
18 of this convenient.
you go for the
I am for the petitioner. He is for, my Lord.
which concern from the other side as for this after
On 16th of December or 18th. My Lord, my Lord, my Lord, it was hearing was concluded, my Lord. The written argument also submitted, my Lord. Earlier, my Lord. It was remanded again, my Lord. Remanded back, my Lord.
27 November.
Obligement.
There has been a total of 15 adjournments, and your lordship had part heard the matter on 3/9/2025, and still thereafter, my lord, 3-4 adjournments have been taken as a matter of court. Sometimes some difficulty, sometimes personal difficulty. Today it has been fixed for final disposal. Now at these are at 2 p.m. he is making a mention. This is fixed for disposal.
Item from production list fixed at 2 p.m. Item 1, WPC 6455 of 2025.
May I please, your Lord. Before I start, Doctor, a similar order was passed by the Honorable Court. Handed over the order. Matter pertains to the recruitment which was quoted by the state respondent with regard to the postgraduate teachers in Bengali and advanced Bengali, wherein the cutoff mark, as declared earlier, was subsequently increased. And that is how the petitioners are being held to be disqualified. Now, Lordship, Annexure 13, page 58. Today, this notice was given on 10/11,
Page number?
page 58, Annexure 13, page 58. Subsequently, the state respondents have published this notice on 10/11, wherein they say
It is 2 p.m. now.
this, Your Lordship, if I just mark out, orientation comes ceremonial distribution. This is ceremonial distribution of appointment address will be given. So, it comes,
So it is 10 now.
yes, sir. Then also, Lordship, question here is about the legality of the
Relative, but arrangement of they have started distributing the
no, it's only, my understanding, it's only ceremonial distribution. The whole
Yes.
the distribution will not be completed. Only a ceremonial distribution.
no.
As the if your lordship kindly take the notice,
No.
must attend the
That
orientation.
is 11th hour.
So the problem is that the petitioner are admittedly on higher merit.
That's all right, but you were too late.
The question of no third party right to be because as per my instruction, posts are vacant. Posts are vacant.
Poster vacant.
Yes, sir. Posts are vacant.
The cut here. Then outlet will not pass anything for that.
That will be taken
We
after.
talk about Monday regarding availability of vacancy. Or the cap or cap on the current book. Is the matter on Monday? So as we have Mr. Rathod here to obtain extracts of whether any vacancies are there or
Obliging.
Item fixed at 2 p.m. for motion, item number 27. Item numbers 2 and 3. Part
Matter was part heard.
which one? Page number?
Made it.
Date of birth 100
Made it.
yes.
Yes, point out here. Right. But the about right here can the power. Power takes power. Trans power does not take power. The output the PN power and would be void. The effect power is therefore this effort of the power and mass is considered in the code as power is equal to so X by well the where is there where is the X yeah, there the what the mass is the by S order of or the position and power order the position and the by the is I think based on the of there is the of the and Lord it does die. But that's not very much confidence. Even there is a rule or law. Own does not the method of the now I regarding that is not on a as as a part. There are I there are one. The content what I thought that that not the good word but there what of the effect of the
order the what are not different. Is for where or equate by cross what depth the whole the equal what is depth also the equal not if the taking a result of the previous the other now there are one part by one of here then the recording right the different for equal on the order and the here is you know variance the result for the equal here and this record and then and pass the order data recorded and in order the education center right not for this other take this take it for the where a commandant is moved from bank by applying or an analogous provision and approach either the high chart or good chart good well as log or the I don't know. The finally by laws of the word find the code of action of by any way the action the code is considered then the recording of by the yes, the power on part of this is that law and the input and during the data become by the code about them like order like whether the results are damaged or the code must is of the what then is just an the paper the light then it and not as if whether the not the move where the code or the record
by the authority and word under the prevailing which dot 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 as something by the now the essential is well said that the High Court in effort does operate the court might not examine whether there was a this or now there are in a power of the court whether the is by an error of law. The case whether it is by error apparent from the face of the record, whether the error self-evident from the face of the record, or whether the error requires examination or argument as the error has been established by a person on point where there is it cannot say an error on the face of the record as held by court. For more than half adopted, but not of the European opinion or students thereof, or is some clearly wrong law be corrected by the dispute by the power wide enough was unknown for it to that no if I arrive at daily life struck down by the record, they may be regarded as part. However, the power of the court to accept the of an order of the authority does not the as the case of what the court or are but it is the court that the dispute does not it it becomes the or can as well as there are the one not part by the court the return that cannot affect the but is the 30. Why was started by four that last part. And the was 5 on after the was over. Even if the common substance is out of it is 5 inside so has over the third care of the order uh, and we have certain order that the court is the one. I think it error but it was it with or or that it was I have uh, recording and there was also why teacher covered recording why this was that is for the that was not the efficiency having it and then are about
So, what- after his arrest, he was sick.
but the breakup sleep I and 4 days family was there after family November it was
They did not allow me, and that is why the contempt petition item number 3 is pending. I wanted to join, they did not allow, despite a stay order of this court, and that is why we have filed contempt petition.
no communication is there he does not when is their conflict will be over after long There's no
No, see, notification stated 25/9/2021. Here it is stated that entry of the above three persons is restricted inside the Guwahati University campus henceforth. No, that kind of Mr. Pupon, that kind of argument will not stand.
detail of but that about aware about that. One part is aware that he has been resisted, but the other part that he has been terminated effectively answered. The reason has suppressed material text. The reason has suppressed material anywhere about any physical representation join the unawareness on his part and non-maintaining of aspect. Tenure is one. He has been granted bail on 8th November. Here there is
Was see that restricted application dated 25/9. So all these nitty-gritties in the then are
I
This is not a part of the record, man. This written note has been freshly handed over to me over the counter. And practice of this High Court is we go by statements sworn on oath. This is not sworn on oath. He has filed 3 affidavits, and now today he has given a fresh note over the counter. This is not the way, my lord. This is not how we conduct court proceedings. He's an experienced man, my lord.
my land. And my affidavit as well as I the entire aspect of the bill which has been after it and if
You can
there is a after sharing both supply has allowed the respective zone to file an and accordingly an file their product relevant record but the exception file earlier has also been cleared in the there. Under the provision and for the prior has been hard to enter the campus that processes that part along as per the employee as asked by the by the that the violence of health according to the evidence and the context the good plan of the experiment regarding the when it yeah, that as we did and so that that what prior plan as we did the and I regard of the order if there is any omission of wrong as well as well there are under it is it
Yes, so in respect of rest of the citation, I will go through the same. No need to delay. Pardon? Hmm. It is, you have mentioned it in your affidavit in opposition. No need to the thing. Sir, it is well settled that if it is not there in the order, by way of an affidavit, you cannot supplement the same. No, regarding the region, regarding the region,
whether
that the Maninder Singh Gill case,
uh, uh, it was the- so there are one here. Misquotation of or any home get either and the don't not take, but those don't see not necessarily affected the family. So the record and it is as per direct if I have punished the record without any so the good direct was there and it is submitted along with we go to the account of the fund.
where is the record?
Your Lordship is the order dated 17/9/2025. Says my learned friend was directed to retain the record. The records are with him.
The record produced by Mr. Fukan shall be retained.
Yeah, it is. Yes.
Along with it, engagement. There at that time was discussed. After here about he has been granted it, but that was not given by her. No, no, no immediate answer. From November 2021 up and the content that may be unaware about. The other hand, that he has
Respond in a brief manner. My case before your lordship is a very similar case, man. Firstly,
No, you are not supposed to again restart the
no,
entire-
I'll not restart.
entire
I'll
matter.
just point
You
out,
have to reply to his submission briefly.
my lord, briefly. Look, firstly, my lord, if your lordship kindly sees the impugn order, page 38, your lordship will see my entry itself was restricted. And I had filed an RTI, page 41, my lord. Page 41, my lord. And I sought that's this impugn termination order, which was never provided to me. Then I come before your lordship, my lord, and your lordship on 36/2022, if your lordship kindly sees the order dated 36/2022, your lordship had stayed that order. Kindly see, my lord, paragraph, my lord, 10, order dated 36/2022, paragraph 10, my lord.
Yeah.
Considering the aforesaid reasons on a prima facie case being made out and the balance of convenience as well as irreparable loss that petitioner may suffer, in the interim it is provided that the notification dated 25/9/2021 terminating the petitioner from his engagement shall remain stayed until further orders. So this honorable court was pleased to stay my termination order. Now after that, what happened, my lord? After that, I had my services got regularized by another court order. Your lordship will see page number, my lord, page number 92, running page. Page number 92, running page, my lord. serial number 3, my lord, my name is reflected. Page number 92, my lord, WPC number 4271 of 2018. Running page, my lord.
Four three nine three.
4393, my lord. 4393, my lord. Page 92, my lord. Page 92, my lord.
Yeah.
Page 92, my lord. WPC number 4271 of 2018, my lord. Serial number 3, my name is reflected. And operative portion, my lord, will find at page 101. 101, paragraph 12, my lord. 101, sixth line from bottom, paragraph 12, line starting from although Mr. Foucon. Although Mr. Foucon has submitted that the services of the petitioner number 3 in WPC number so and so has since been terminated on the ground of committing misconduct, this court is not considered with the said aspect of the matter in the present proceeding, since the order of termination has reportedly been assailed by him in another writ petition which is pending before this court. And operative portion, my lord, will find page 104, paragraph 19. Paragraph 19, my lord. Paragraph 19. For the reasons stated above, this court is of the opinion that all the writ petitions must succeed and are hereby allowed. The writ petitions are therefore disposed of with the direction upon the respondents, more particularly the registrar, to process the cases of the petitioner in light of the observations made herein above, and thereafter take necessary steps for regular absorption and regularization of the services of all the writ petitioners by issuing necessary office orders. So, my lord, as on date, 2 orders of this court has been violated. Number 1, my lord, the stay order dated, my lord, 36/2022. Till now, they have not allowed me to resume my duties. And number 2, my lord, the second order, which your lordship in a coordinate bench had directed to give me pass necessary orders for my regularization. That also they have not, my lord, complied till now. Now, my lord, once I file this writ petition before your lordship, they file an affidavit on 28/7/2022. In the first affidavit, my lord, they take a bizarre stand that the matter has become infructuous. And in that affidavit which was filed, there was not a single whisper that, my lord, the inquiry has been dispensed with. Now, what had happened, my lord, on 27/2/2023, the hearing of the writ petition commenced. Page 124, my lord. If my lord kindly turns to page 124, this is what had the matter was part heard. So once the matter was part heard, they realized that there was a mistake in not conducting a departmental proceeding against me before terminating me, and therefore they took a complete fresh stand stating that, my lord, the inquiry against me has been dispensed with. Now, my lord, even if for argument's sake, assuming that they have dispensed with the inquiry, then also it doesn't stand the eyes of law. My lord, just my learned friend had referred to Tulsiram Patel, but these are some of the latest judgments. Southern Railway. I'll place 2024 latest judgment, my lord. Tulsiram Patel has evolved in present times. We have to read Tulsiram Patel as it stands today, my lord. Southern Railway 2009 Southern Railway 2009 9 SSC 25 Southern Railway. Just I will not trouble your lordship with the entire judgment. Just two paragraphs. Paragraph 21, my lord. Southern Railway Officers Association.
Yes.
Paragraph 21. Indisputably, holding of an inquiry if any misconduct is alleged on the part of the delinquent official is obligatory, wherein the delinquent employee is to be informed of the charges against him and given a reasonable opportunity of being heard in respect of charge thereof. The second proviso appended there to, however, makes 3 exceptions in regard to the constitutional amendment to hold an inquiry. Clause B whereof provides that in a case where the disciplinary authority is satisfied that it is not reasonably practicable to hold such an inquiry, subject to course of the condition that therefore the reasons are to be recorded in writing. Recording of reasons thus provides adequate protection and safeguard to the employee concerned. Now, my lord, this is important, my lord. It is now well settled that the reasons so recorded must be cogent and sufficient. Satisfaction to be arrived at by the disciplinary authority for the aforementioned purpose cannot be arbitrary, it must be based on objectivity. And my lord, paragraph 23, operative portion, my lord. Tulsiram Patel has been explained. Paragraph 23, my lord. The law laid down by this court being clear and explicit, the question which would be arise for our consideration is whether in that prevailing situation what a reasonable man taking a reasonable view would have done. And my lord, coordinate bench, my lord. These are latest judgments of our Honorable Guwahati High Court. Ruben Kolita. Ruben Kolita. Okay. I will only read out the relevant portions, my lord. I will not trouble your lordship with the entire judgment. Ruben Kolita, coordinate recent judgment, 2023. Paragraph 17, my lord. Ruben Kolita, my lord. Paragraph 17, my lord. May I just read out?
Yeah.
Coming to the facts of this case, as noted herein above, the reason as to why the disciplinary authority had felt that it was not practicable to hold an inquiry against the petitioner have been recorded in the impugn order dated so and so, and the same has been discussed herein above. Applying the ratio of the decisions referred to in the foregoing paragraphs of the facts of this case, this court is of the opinion that the reasons recorded in the impugn order were neither adequate nor relevant for the authorities to invoke clause B of 311(2) of the section so and so of the CRPF Act and rule so and so of the CRPF rule and dismiss the petitioner from service without holding. So, my lord, the reasons have to be adequate and they will have to be relevant. And the next paragraph, my lord, the impugn order was quashed. My lord, another coordinate bench, my lord, Ayush Tomar.
No. The boys that
It's not a settled, my lord.
you were referring that
And just one which culls out all the judgments. It's a very, the coordinate bench has taken a very exercise. Just one paragraph, last paragraph. Mohammad Hussain Ali, my lord. Mohammad Hussain Ali, my lord, 2022 5 JLT 263. Paragraph 15. In fact, paragraph 18. 18 and 19 settles the issue. Mohammad Hussain Ali. Paragraph 18, my lord has got, my lord. Mohammad Hussain Ali. Latest judgment, my lord. Paragraph 18.
Yes.
The impugn order of dismissal nowhere reflects any satisfaction that it was not practicable to hold an inquiry. No assessment was even made to come as to such a conclusion. No separate reason in writing for dispensing the inquiry were recorded and preceded the impugn order. Therefore, this court unhesitatingly holds that while issuing the order of termination, the responsibility has failed to perform its obligation under Article 1011. And here also, my lord, the impugn orders were quashed. Now, my lord, coming back to the reasons which were put forth by the Guwahati University, my lord, kindly see the reasons. I have dealt with each of the reason at page 119, my lord. Page 119. The first reason they say is that the petitioner was under the police custody. Now, my lord will kindly take up the rule for a moment, the Guwahati University rule. Rule 45, Guwahati University rules, my lord. Rule 45(2). Rule 45(2), my lord. Guwahati University rules, my lord. Suspension, my lord.
1970.
1970, my lord.
Okay.
Rule 45, my lord. Rule 45 deals with suspension. Subclause 2, my lord.
Yes.
An employee who is detained in custody, whether on a criminal or otherwise, for a period exceeding 48 hours shall be deemed to have suppressed with suspended with effect from the date of such detention by an order of the appointing authority and shall remain under suspension until further orders. So, my lord, whenever this is perimeter with Rule 6.2 of the Assam Discipline and Appeal Rules. So, whenever a person is in the police custody beyond 48 hours, a reasonable person would have issued an order of suspension. Just because the petitioner is in police custody, they cannot straight away issue the impugned termination order, and that too with, my lord, extremely stigmatic remarks. 45.2, and kindly see, my lord, Rule 46. Rule 46 defines the nature of penalties. They should have resorted to Rule 45.2. I am no one to advise them. But that is what a reasonable man would have done. By issuing a stigmatic termination order, it shows nothing but the vindictiveness of the authorities against this person. They are so vindictive that they have not only terminated me from service, they've even, my lord, restricted my entry into the Guwahati University campus. The impugned termination order itself smacks of malafide. And my lord will kindly see, my lord, Rule 46. 46 subclause 8. 46 subclause 8, my lord.
Yeah.
That is dismissal from service. Now, to inflict a punishment of this nature, the procedure is at Rule 48. Kindly see the procedure, my lord. Procedure for imposing penalties. It lays down the procedure. Very perimeter with Rule 9 of Discipline and Appeal Rules, show cause, reply, and there has to be some evidence, and there has to be a recording of guilt. And then, after giving an opportunity of hearing, my lord, natural justice, they can terminate me. But not in this manner. And my lord, second reason which they have provided is that the DP will be lengthy and time consuming, my lord. Can it be a cogent reason, my lord? This is a question I'm asking to my own self. Can it be relevant reason, my lord? Is it based on objectivity or is it based on the subjectivity of that particular officer? The second reason, that DP will be lengthy and time consuming. You are the person who is conducting the inquiry. You can expedite the process. Just because a DP might be lengthy and just because a DP might be time consuming, my lord, on that ground, my lord, in my humble submission, my lord, this is nothing but pure vindictiveness, my lord. And these are the judgment, these are the, my lord, basic reply, my lord. And if your lordship kindly sees item number 3. Item number 3, my lord. Contempt case number 423 of 2022. My lord will see the order under contempt, page number 11. So I have already read out. They have not complied with they have not allowed me to resume my duty. And in the reply which they have filed at page 15, it starts at 15 and ends at page number 19. There is not even a single apology for not complying with the court's order. Not only one, 2 courts ordered they have flagrantly violated as on date. They have neither allowed me to resume my studies, resume work, despite a stay order of this honorable court. They have not even regularized my service, despite another court order. And when I file a contempt, they file an affidavit. They don't even, my lord, apologize to the court that we are sorry that we are not, for these reasons, we are not complying. This is nothing, my lord, willful disobedience. This is playing with court's order. These are the basic points, my lord. And this even if we assume that these reasons which they have given for dispensing of this inquiry are not afterthought, even then also they cannot withstand the scrutiny of law, my lord. That is my humble submission, my lord. And if your lordship requires a written note, I can give it tomorrow. And if your lordship is satisfied, my lord,
You can give it because you have completed your argument long back.
I have completed. I have completed. Just for refreshing the memory. If required, I can give it tomorrow morning.
Okay.
This is the sum and substance, my lord.
So, Borua,
My lord.
this consider better prior to the decision with 2000 referred by you.
My lord, which one, my lord? My lord is referring to
Southern Railway.
Southern Railway, 2009.
Yes.
My lord.
This is of 2000.
My lord.
Is of constitutional ban.
Constitution man. But then this Southern Railway, my lord, it interprets Tulsiram. Tulsiram, which was rendered may I just show one thing from Tulsiram itself? Your lordship kindly takes up Tulsiram itself, my lord. May I just show one thing? Kindly come to page 504. Kindly come to, my lord, page number 104. 10th line from the top. Page, 504, my lord. Page number 504, Tulsiram. 10th line from top. Southern Railway Tool. Has your lordship got it, my lord?
Page number?
Page number 504, my lord.
Paragraph number?
Paragraph 130, page 504, and 10th line from top, my lord. Page 504. The line starting from a disciplinary authority. Has my lord got it, my lord?
Yes.
It says a disciplinary authority is not expected to dispense with a disciplinary inquiry lightly or arbitrarily, or out of ulterior motives, or merely in order to avoid the holding of an inquiry, because the department's case against the government servant is weak and must fail. So, my lord, Tulsiram itself says, because otherwise it will be chaos. If an officer doesn't like any junior officer, all he needs to do is simply issue a termination order and write in the records, we are dispensing with the inquiry. He won't even get a chance to come before your lordship. The moment he comes before your lordship, they will say, we have dispensed with the inquiry. So they cannot do it in a light manner or because you're playing with a person's life. Article 19(1)(g) and 21 is directly involved. It's a serious issue, my lord. You're throwing somebody out of livelihood in a knee-jerk reaction. It is not something which has to be taken lightly. So Tulsiram, we should not misinterpret, my lord. Tulsiram says you cannot lightly, and it is based on Tulsiram that this subsequent judgments of our my lord, Guwahati High Court have come. If your lordship sees all these local judgments which I have produced before your lordship, whether it's Ruben Kolita or Ayush Tomar, my lord will see Tulsiram has been, kindly see, my lord, one local judgment, Ayush Tomar. There Tulsiram has been explained. After my lord, paragraph 17, it says,
all right.
Well, so my lord, Tulsiram should not be misinterpreted, man. That is only my humble submission. Obliged, my lord. Deeply obliged. My lord. My lord. I will put it serious.
There are lot of judgments in the price.
Yes. Otherwise difficult. And tomorrow morning, my lord, I'll give one small note for your lordship's convenience.
Okay. But hand over one copy.
Yes, I'll give. Just 2 pages, just for lordship's convenience, my lord. Obliged.
No, it is already there in their additional affidavit. Yes.
My lord. And
Therefore, yesterday you have been asked to apply on whether
I
so how many students are there according to your information?
Not 330 is here as per our structure. Milord. We have stated on our Milord. Lord, may kindly take up this. This is issued by the Milord, Assistant General Manager, APDCL Borpeta. Not wherein it has said that rupees 12,78,242 rupees is pending, Milord, in the name of the Ekolopo Model Residential School, Dolbari, Boroma. So for this non-payment of this bill, Milord, the electricity had been disconnected. Now, Milord, apparently the school is functioning, Milord. There are students. The school is functioning and operating. That's why this consumption, Milord, in the meter reading has also shown that. Now, we are for the students, Milord, and the monies are being, Milord, handled by the district committee at this moment. Had they paid the bill, this is a calculated attack on the, Milord, schools and the administration, that if we do not pay the bill, automatically the electricity will be get disconnected. My lord, this is the report. So, Lord, this yes, it has been disconnected, but prior to this disconnection, these are the pending bills.
So where is the committee? So who has been interested to run
My lord, the committee, yes. My lord, the committee, my lord, may be pleased to find in my petition, my lord. My lord, kindly turn to page 62, my lord.
Yes, Annexure 6.
My lord, Annexure 6, my lord, may be pleased to find this is a letter issued by the Deputy Commissioner Baksa Musalpur on 13/7/23, addressed to the Sri Ramakanto Musahari, Chairman, Management Committee, Boruland Model Tribal Education Society, Dolbari, and so and so, my lord. So this is the committee, my lord, and who is now handling the administration and management of the school, my lord. My lord. No, my lord. No. Somebody else. We are not somebody else, my lord. We are the, my lord, principal and the other staff, my lord, who are facing the. Now, my lord, may kindly. Now, my lord, may kindly read over the contention, my lord. In inviting a reference to the subject cited above, I am to inform you that the district level management committee for EMRS Dolbari will take over the charge of EMRS Dolbari on 14/7/2023 at 10 a.m. as per the resolution taken by the DLMC in the last meeting held on 7th of July 2023. My lord, now, my lord, the district level management committee for EMRS Dolbari is now, my lord, managing the affairs of these schools, my lord, and this is a, lord, but they are a party to the proceeding, my lord. If somebody is sitting silent, my lord, not taking care of the institution, not taking care of the students, my lord, then somebody have to take a call, my lord, because we are the, my lord, person concerned, and we are, my lord, managing the affairs of the school at the grassroots level. taking up the classes, my lord. We have not been debarred from taking up the classes till date. And now, my lord, on the last time, a submission had been made that there was no school and no correspondences is there. My lord, we have collected some of the documents. My lord, I am very sorry. My lord, I am handing over these documents on paper, my lord. My lord, kindly for a moment, my lord. It will clarify the entire here. Here. My lord, if you go by this letter, my lord may be pleased to find this is a letter issued on 7/1/2020, issued by the my lord so-and-so Director WPT and BC to the Regional Officer CBSC Regional Office Silpagram Road so-and-so. Examination Center at the Ekalapo Model Residential School in Dolbari, Baksa. With reference to the subject cited above, I would like to inform you that the Ekalapo Model Residential School at Dolbari, a district Baksa, has been functioning since 2013 under the aegis of the Ministry of Tribal Affairs, Government of India, for imparting free education to the poor ST students. The school is affiliated to the CBSE since 2017, with so-and-so being affiliation code number and school unique number so-and-so. It is pertinent to mention here that the school was given the center number so-and-so and so-and-so for conducting so-and-so during the last 2 years, that is 2018 and 19 respectively. But during 2020, the students of the EMRS Dolbari were allotted the examination center at so-and-so Adalbari, Baksa, which is at distance of around 30 kilometers from their school. It will be difficult for the students to travel to the examination center owing to transportation costs, as most of the students belong to the poor family. I therefore request you kindly to allot the examination center at EMRS Dolbari in the interest of the students from the year 2020. Now, my lord, may kindly turn. My lord, this letter clearly reflects the position when it was affiliated, what is the code number, and from which year the school had been functioning. My lord, it is here. My lord.
Whether any writ petition was prepared by the school in respect of this examination center?
That, my lord, that.
Dismiss or withdrawn?
It is not within our knowledge. It is not within, maybe, my lord, as my senior friend is telling that it has been dismissed. But my lord, our case in this petition is very limited, my lord. That we are, my lord, the Ekalopo, we are before my lordship as a Ekalopo Model Residential School Dolbari, represented by the principal. Now they are, my lord, disputing our entity, my lord, that we are not the authorized persons to manage the school. My lord, then there may be somebody, some teaching staff may be there who is managing the affairs or taking up the classes. That can be produced by my learned, respected friends, my lord, which they have not. Now, my lord, therefore, our my lord, prayer today for the interim prayer is that, my lord, the electricity should be connected by following the due procedure of law. And secondly, my lord, the students who are in the model residential school are foodless, so the minimum, my lord, basic food should be provided. We are not asking any benefit for us, my lord.
No, that's all right. No, madam, no, madam, see, page number 82 of their affidavit, additional affidavit. This account of the school is managed by EMRS Management Committee of Baghdad.
My lord.
Maybe. Then the deputy commissioner is a party.
Chairman,
Then
he's
we
the
have
chairman.
for deputy. Respondent number 15, deputy commissioner. Yes, not served a copy, but
My
you are here. Let the deputy commissioner make payment of the
Let-
dues of the ACB from this account. Here, the sum of rupees 63 lakhs 19,331 rupees are there. No, you cannot compel the court to record your expense. This is the prerogative of the court. Don't make such kind of stuff. Here, I don't know. Okay, what- Yes. Uh, and we did and maybe that aspect will be forget about forget about that pair. You say now there is no electricity in the school. 330 students are there. They have no food to eat. Then on what basis you have allotted crores of rupees to the school? That was for construction, my lord. We are constructing. We are my lord, appoint the- No, you say how on what basis the CPSC has my lord will recognize that institute? Not be public bank. That means this court will allow the students to starve and die. Is it? Yes. Oh, okay. Let them file their affidavit. In the meantime, that's not the electricity connection to that. So you see, in the school fund, school account, there is fund. I am not even getting it. No, you have been served with a copy of the additional affidavit. Sir, no, maybe, but there is fund in the account of the school. No, no. This statement is of Mr. Bhuya of which
My lord.
is page number 82.
Yes, page number 82, my lord.
7/10/2025.
Yes, my lord. It is of statement. my lord, 1/1/2025 to 27/10. Statement summary, my lord, maybe please to find at page 82 bottom, my lord. Statement summary 1/1/2025 to 27/10/2025. It's a up to date updated statement.
Yeah.
নহয় বাইদেউ এইটো লাষ্টত statement. My lord, I don't know, my lord, my lord, restraining the interim order, how the students are going to be benefited. My lord, I can that Locus and my lord, my respected senior friend is vehemently objecting the interim order. I know, my lord, but we are not that we should be benefited. The students should be benefited. The deputy commissioner is the authority, my lord. He can do the
Yes,
needful, my lord.
Madam Verma, you talk with the deputy commissioner. After some time, you let this court know that he has to make payment of the electricity from this account, and he also has to provide food to the student staying in the hostel. You obtain inspection, let this court know after some time. And Madam, first you see the amount in the account of the student. Yeah, page number 80, page number 82.
Please, for the writ petition, this matter was heard, and I had put in my argument and
So today, Mr. Verma has to produce his
record
record.
of the disciplinary process.
Yes. Okay. Argue here. Argue. Hmm. $29. Page number 20. the money. MEX. Do that. When he has been warning letters and all, and he what he has done, he has deposited the amount of the concerned respective bank account of the customer. And has acted in the deposit date. That date is the at then the entire amount. Whether whether the bank maintains any register so that receipt of the funds from the receipt of the sum from the depositor. The lordship at the time argued for control, but control was not there at that point. Why? Not that initiate that. Because in the case that the person concerned has come up for the deposit the money in his account. Now after the money directly to the cash account. Now you are maintaining the scroll register. But at that point of time, it was not there. It has taken the NEX 4 your but it was the NEX 4 also. Also, your NEX 3 is the apology letter. Yes, sir. It is the effect of the summary. Then NEX 4. NEX 4 along with the NEX was taken in custody by police. Okay. Is it? The first set. Yes. Yes. If you're not EX4, there is a mark that the certified copy marked by the police Thana. That's not succeeding. And the case has been declared as not succeeding. 2020. The coming date is 3/12. And your Lord that all the cases were duly signed by the treatment that has not been disputed in this exam anyway. That's an admitted fact. All the pages were signed that the money that has been deposited he himself has accepted and the letter is written in SB. NEX wanted a person from the authority that may be allowed to deposit the second NEX 4 he has deposited the amount. On 10/11 he has deposited some amount. On 18/11 the entire 6,000 has been deposited. And all the pages were duly signed by him without any. Yes. Then your Lord, it's 5. That is the he's saying that I have deposited all the amount. Accordingly, I will be it.
by the court. There are three dates that the inquiry was conducted. Inquiry was last inquiry. He never did any mark any of the points that he has not disclosed the amount. He has not said anything. But he has been asked that it is not
Yes.
later dated was also examined. That then there earlier on all these different account there the very eight eight thereafter you at the conclusion yes, by you affected yes, your God delayed and he has never entire examination. He himself has not paid the money that has been taken by the customer and that has been posted on various no case doubt. Enough about it. But once never did, now he raises the question on the inquiry. He himself said all the documents that shown to him during the inquiry that has got it. And the page has been signed by the written. My case is not that there is no evidence of the record. My case is not that there is no preponderance of the property. And there is no lapse in the decision. So, as far as the three criteria that has been identified, and there was no dispute of documents, he himself has said one of them, no, I do not remember.
So the
Now, your
statement, you have produced of the statement of the witnesses yet?
yes, Your Honor, I have
Statements of witnesses are not recorded separately. Your lordship will find at the inquiry proceeding itself. There is no separate, it is in the form of question answer. I have given that inquiry proceeding.
No, sorry, whether the petitioner was allowed to protect himself,
Yes,
he was allowed.
he was allowed. He was, his
Whether
defense-
any defense assistance was sent
yes,
to
there was a difference. So, I'll reply, my lord. Let him complete, then I will reply.
yes, complete.
He has completed. Now, my lord may have a look at the inquiry proceeding as regards the maintenance of the scroll register. If your lordship takes up the inquiry proceeding, and the other day I had given that inquiry proceeding. That my one is also inquiry proceeding. Perhaps মই দিয়াটো দিয়ক তাতে পেজ নাম্বাৰ কৰা আছে তেনেহ'লে নাই এনেকে
Do you have any extra copy?
I have the one
Otherwise, you can
now.
tell me the pages because the original is before this court.
Yes. Now, if your lordship takes up the inquiry proceeding, cross-examination of MW1 was held on cross-examination of NW.
After the survey?
After the first page, it is a preliminary inquiry where your lordship can also take note of this fact. There is a question put to the charge sheeted employee. Having read and understood the charges, do you plead guilty of the charges leveled against you? He said no. So that is why this entire inquiry. My lord, first page of the inquiry proceeding held on 7/5/2022.
Yes.
So there is a question. This is the last but one question. Having read and understood the charges, do you plead guilty of the charges leveled against you? He says no. Then is the cross-examination of MW1. That your lordship will find the proceeding that was held on 24/5/2022. After the examination in chief of MW1 was over, the proceeding, the fourth page of the proceeding of 24/5/2022. So your lordship has got it. You may cross-examine MW1. Lordship will see the cross-examination of MW1, who was the branch manager, not at that relevant point of time, but was the branch manager when this proceeding was held. Now, the first question, please tell what is the procedure for cash deposit in the branch? The customer should deposit money after marking serial number, account number, and amount of money to be deposited in pre-call register, and the same serial number also to be marked in the cash receipt. Now, my lord, in the entire evidence, there is no statement that the branch was not maintaining a scroll register. A statement has been made now that there was no scroll register. But The MW1 in his cross-examination admitted the procedure for depositing the cash. The inquiry officer, without there being any evidence that the branch was not maintaining a scroll register, came to a finding that there was no scroll register. If the scroll register was not maintained, then the MW1 would not have given a detailed description of how cash deposit is made. Is very specific. The customer should deposit money after marking serial number, account number, and amount of money to be deposited in pre-scroll register, and the same serial number to be marked in cash receipt register. Now, please peruse MEX1 and tell whether pre-scrolling was done in all the vouchers. Said no. So, now, my lord, I am just pointing out one thing, my lord. The allegation says I received money on XYZ day and I did not deposit. The first thing that is required to be established is that the person came to the bank to deposit money, and that can be established from the pre-scroll register, because the account number, name of the account holder, the amount to be deposited is entered in the pre-scroll register, and that serial number is given in the deposit vouchers. Why this is made? Because at the end of the day, the cash received is tallied with the pre-scroll register. How much? Because the person who is making the deposit, receiving the deposit and making payment, then to maintain that, how much money the branch had received on a particular day, cash amount, is maintained in a pre-scroll register. This is the amount of receipt and the total payment made. Because this, at the end of the day, when the cash is tallied, it has to tally. Now, my lord, where is the evidence? Lordship has gone through the record. Is there any account statement that on the day when which that voucher is dated, the bank has received money or the employee had received money, he did not make the deposit? Because it can be established, I receive money, if I don't deposit, it will be reflected from the account holder's account statement. Perhaps I could make it clear to a lot. I receive money on today, and allegation I don't deposit in the account. So it can be tallied, the received vouchers plus the account statement of that account. Yes, on that day, no amount is credited in his account. Where is the account holder's account statement in the inquiry? Lordship has seen the record of inquiry. It is not there. Now, the inquiry officer has come to a perverse finding that there is a no scroll registered maintained. Where is the evidence? Where from? Lordship is aware when a person is conducting an inquiry, he has to go by the record and the evidence placed before him. He cannot exercise his power on the basis of his personal information, which is not on record. This finding of the inquiry officer that the branch did not maintain a scroll register is not borne out of the record. Another aspect, my lord, the issue of complaint. So many persons had deposited money and not a single complaint is made. No whisper in the charge sheet that the depositors made complaint. Now, the MW1, when asked by the presenting officer regarding any complaint, an objection was raised by the defense assistant, and the inquiry officer sustained that objection. However, later on in the report said that on the basis of verbal complaint that everything was done. I can show it to your lordship, that question also. In the inquiry proceeding, lordship will have that inquiry proceeding which is marked. That is the inquiry proceeding of that day when the MW1 was examining, his examination in chief was going on. There is a question, it is not marked, PO to MW1. Have you received any verbal complaint in this matter? Have you received any written complaint in this matter? MW1 said no. Then have you received any verbal complaint in this matter? Yes. Who has made this complaint? Now there is an objection. I will make objection here since there is no mention of any complaint received from any customer, whatsoever, and not mentioned in ME1. So the question is not relevant here and may not be allowed. Objection is sustained. The inquiry will proceed based on ME1. So the inquiry officer did not permit the presenting officer to bring on record the fact whether there was any verbal complaint or not. However, in his report, he recorded a finding that there was some verbal complaint. Lordship may have a look at these three questions and what the inquiry officer observed. Inquiry will proceed based on ME1. ME1 is the charge sheet, and the charge sheet is silent about any complaint, either made written or verbal. Now, in his report, the inquiry officer is saying that the branch acted on some verbal complaint. Now, if it is on verbal complaints, then if I am not given the opportunity to cross-examine, if those persons are brought in the inquiry, how can such complaints be acted against me? Now, my lord, another aspect, Lordship will have a look at the order of penalty. Before that, the Lordship may have a look at the chart. The charge sheet, your Lordship will find at page 28. Charge number 1 and charge number 2, and then at page 30, what the bank is saying basically, your above reported act, if proved, will amount to doing any act of gross negligence or negligence involving or likely to involve the bank in serious loss. That is gross misconduct under 5J. My lord, yesterday on the last occasion, I had given your lordship that bipartite settlement which is governing this particular employer-employee. Now they are saying that it is bipartite settlement of 10/4/2020, 2002. I have given that bipartite settlement on the last week when the matter was taken. Whether your lordship has got it, bipartite settlement. Record to বুলাই দিব পাৰি। এইটো লুজকে দিয়া হৈছিলে লাষ্ট উইকত। নাই নাই, it is not, এনেকে হ'ব। Bipartite settlement dated 10/4/2002. Record to delay. Record to if a lordship permits me to go through the record, I'll perhaps I'll be able to find out. Record inquiry proceeding, the copy that was served upon me in original was also handed over to your lordship on the very first day when the matter was argued in the month of
No, it
September.
was in the file, but the file is usually goes to section
but those documents should be kept.
But those are not available now, the record.
Now, for a moment, I can share my copy, but
Okay.
I'll have to make a photocopy once again. Right now, I don't have any extra copy.
Okay.
If your lordship goes through this settlement 5J, which is the allegation leveled against me is that I have committed a misconduct under 5J of the bipartite settlement, which is a gross misconduct. Now 5J speaks of, I have marked that black with black ink. 5J has two parts. One is any act prejudicial to the interest of the bank or gross misconduct exposing the bank to loss or likely to suffer loss. Now they have charged me for act of gross negligence or negligence involving or likely to involve the bank in serious loss. That is the second part of that. If your lordship 5J in the charge sheet, lordship will see your above reported act, if proved, will amount to doing any act of gross negligence or negligence involving or likely to involve the bank in serious.
Mm.
So they are charging me for involving or likely to involve the bank in serious loss.
Mm.
Now, my lord, this is the charge. There is no charge of financial embezzlement. Your lordship will see they have not charged me for any financial embezzlement. Now, in the order of penalty, which your lordship will find at page 55.
No. You come to search number 1. There it is mentioned that thereby misappropriating a sum of rupees 8,69,430 rupees.
But you have reportedly act. Now, this is the charge sheet. You have reported, if you have reported your above reported act, if proved, will amount to doing any act of gross negligence or negligence involving or likely to involve the bank in serious loss.
Mm.
So, in the order of penalty, there is a categorical finding that no financial loss is caused to the bank. At page 55, order of penalty matter. Conclusion. It is observed from the charge sheet. Lordship will get it at the conclusion. It is observed from the charge sheet, reply of the CSE, finding of EO, and the charge sheet that employee has been found guilty of charge amount under gross misconduct under 5J of the memorandum on discipline. So and so I am skipping. I have examined the entire records of the case and agree with the findings of the inquiry officer for the reasons given by him. I have carefully gone through the factual position of the case and applied my mind independently to the instant disciplinary case. As such, I fully concur with the views and findings of the inquiry officer. I have also taken into consideration of the fact that the CSE has refunded embezzled money in full, thus there is no financial law. However, cash embezzlement. Now, my lord, to establish the fact of cash embezzlement, they will have to prove that after receiving the money was not credited in the depositor's account. And that can be established only by producing the account statement of the depositor. And in my humble submission, the inquiry proceeding does not have the account statement of the depositor from whom the money was received. So, my lord, even if assuming that there is an allegation of misappropriation, then it has to be established by three things. First, people coming to the bank have come to the bank to deposit money in cash, and that can be established from the scroll register. Manager is saying that yes, this is the procedure, but he did not say that the bank did not maintain any scroll register at that time. Inquiry officer says that bank did not maintain. So this is for something which is not borne from the record. Number two, the deposit slips did not have the scroll numbers. Number three, this is just one part of the evidence which says the money was received, but it was not credited in the account holder's account, can be established only from the account statement of the account holder. That account statement of the account holder is not there in the inquiry process.
But Mr. Chakraborty, you see, you have admitted before the inquiry officer.
No, it was not an admission before the inquiry officer. I have given an explanation to those letters. If your lordship takes up my explanation, because that bipartite settlement says after the evidence is recorded, the workman employee should be given an opportunity to explain his case. Now, in his explanation, he has stated that it was obtained by force and he was forced to write those letters. And on the last day, I had pointed out to your lordship, this person initially joined the bank as a sweeper, part-time sweeper, then full-time sweeper. By virtue of his position and experience, he rose to that. So your lordship will appreciate that he has gone up to that position from the stage of a sweeper. That is why his explanation. Otherwise, my lord, if this everything is admitted, then what was the necessity of holding an inquiry? If I admit anything,
No.
it is not an admission before the inquiry officer. It was not an admission before the inquiry officer. He has given an explanation that I was forced to write those letters by the branchman. And the inquiry officer is saying that how can a person be forced to write such letters? In any case, my lord, where is the evidence to show at least that is an essential component of the charge, that money received but not credited. Whether it was credited or not credited can be concluded only from the account statement of those account holders. So, my lord, this is a case, the bank themselves were saying that no loss is caused to the bank. But the fact of this financial embezzlement, whether it is established from the end, lordship will have to examine. Because on the last day when I decided, I have cited one decision of Rup Singh Negi, 2009 2 SCC 570. At paragraph 18, এই judgment to আছে না নাই, copy to দেওয়া হয়েছে, এটাও নাই।
Decision is there.
Rup Singh Negi?
No, this is Allahabad Bank and others versus Vishnu Narayan Keyword.
Lord. That is a, no, I had given the Rup Singh Negi भी दिया था। My lord, 2009 2 SCC 570, Rup Singh Negi.
Thousand?
2009, volume 2 SCC 570.
What is the relevant paragraph?
14, 15, 18.
Yes.
Now, I am reading paragraph 14. Indisputably, a departmental proceeding is a quasi-judicial proceeding. The inquiry officer performs a quasi-judicial function. The charges leveled against the delinquent officer must be found to have been proved. The inquiry officer has a duty to arrive at a finding upon taking into consideration the materials brought on record by the parties. The purported evidence collected during investigation by the investigating officer against all the accused by itself would not be treated to be evidence in a disciplinary proceeding. No witness was examined to prove the said document. The management witness merely tendered the documents and did not prove the contents thereof. We have noticed here and before that the only basic evidence whereupon reliance has been placed by the inquiry officer was the purported confession made by the appellant before the police officer. In that Supreme Court case, there was a confession made before the police. According to the appellant, he was forced to sign on such conclusion as he was tortured in the police station. The appellant being an employee of the bank, the said confession should have been proved. Some evidence should have been brought on record to show that he had indulged in stealing the bank draft. Admittedly, there was no direct evidence. So, my lord, here also there has to be some direct evidence. Mere admission, and when I am explaining that I am an employee who got up to that position from the level of a part-time sweeper, I was forced by the branch manager to write those letters. Now, paragraph 18. In our opinion, the learned single judge and consequently the division bench of the High Court did not pose unto themselves the correct questions. The matter can be viewed from two angles. Despite limited jurisdiction, civil court, it was entitled to interfere in a case where the report of inquiry officer is based on no evidence. It is in a suit filed by a delinquent employee in a civil court as also a writ court. In the event of finding arrived in the departmental arrived at in the departmental proceedings are questioned before it, it should be kept in mind the following. Number one, the inquiry officer is not permitted to collect any material from outside sources during the conduct of the. Now, maintenance of the scroll register, when he is saying that the bank did not maintain a scroll register, which is not part of the record, it's something which he is collecting from outside source, which is not permitted. In a domestic inquiry, fairness is the procedure. So, my lord, I will skip. Now, the inquiry officer is not permitted to travel beyond the charges, and any punishment imposed on the basis of a finding which was not the subject of the charges is wholly illegal. Suspicion or presumption cannot take the place of proof even in a domestic inquiry. Now, here, in absence of the account statement of the depositor who had deposited money, it is highly improbable to presume that the money was not deposited in the respective. This is only on the basis of presumption, my lord. The account statements are not part of the record. So, my lord, here it is a case, in my respectful submission, first, the charge against me is of causing or likely to cause the bank loss. Because of my gross negligence, the bank is likely to suffer loss. But the finding is, or the bank is saying that no loss is caused. So however, I am penalized for embezzlement, but there is no proof of embezzlement in there.
Okay.
And my lord, another aspect, the inquiry officer has recorded. I'll take your trouble, your lordship, by once again pointing out to certain things of the inquiry officer's report, where the inquiry officer is saying which is not part of the record. In spite of that being pointed out to the disciplinary authority, nothing has been given, and why it is rejected. So, lordship comes to page 42
of your
writ petition. 42. This is the analysis of the inquiry officer. After judicially going through the argument of PO and DR, the documents presented before me, it is clear that there were 105 numbers of deposit challans tendered by various customers on various days, but amount not deposited in respective account. Now, this part, my lord, here's analysis, the first paragraph, but not deposited in respective account. Now, where from the EO is saying that amount received but not deposited? To come to that conclusion that after receiving the amount, it was not deposited, it can be done only when the account statement is before the inquiry officer. At the same time, branch has not received any written complaint from customers about not depositing the amount in their account. It is not there because Lordship will have a look from the inquiry report itself, which says what are the exhibited documents. At page 41, Lordship will see the documents which are exhibited. Page 41 of the inquiry report. These are the only documents which were exhibited in the inquiry. Copy of 105 number of vouchers, 53 pages, that is MEX 1, page 41. First, it starts from that paragraph. 32 pages, 94 deposits, vouchers on 10, 11, 21, and 32 containing 32 pages, and on 18, 11, 21, 11 number of pages, exhibit MEX 2, 3 letters of the inquiry charge sheeted employee to the department. These are the documents which were exhibited. There is no whisper of any account statement. In absence of that account statement, he records a finding that money received was not deposited in the account. At the same time, branch has not received any written complaint from the customers about not depositing money. So he comes to a conclusion that there is no written complaint. As per so and so, now, as per Deer's argument, in the absence of any complaint of the customers holding account holder against the CSC, the allegation leveled by the bank falls flat on the face of the record. In my opinion, complaint has been received verbally and MW1 has acted upon the verbal complaint. Now, where is that evidence that there was verbal complaint? If there was any verbal complaint at all, who are the complainants, and was it not incumbent on the part of the disciplinary authority to bring those complainants with opportunity to the CSE to cross-examine those complainants? I mean, in fact, the inquiry officer in his proceeding has rejected the question that we cannot go beyond what is stated in the charge sheet. The fact of, as per Deer's argument, the fact of receiving money from the customers by the CSC could not be established in the inquiry only from MEX 1 in the absence of pre-call register. It is a fact that branch has not maintained pre-call register. If so maintained, then this incident might have been avoided. Now, where is the material? It is a perverse finding. He is recording findings not from the record of inquiry. Maybe from his personal knowledge, I do not know. And we cannot also go. But except few challans as per MEX, all the other challans are having cash receipt stamp, which receiver's signature and amount challans as per tendered by depositor has been written by cash receiver. So there are certain challans which were not even written. There is some dispute regarding the handwriting in certain challans. Now, during argument, MW1 informed that he has received verbal complaint about the incident. Now, my lord, how can the MW1, Lordship can appreciate, inquiry proceeding, MW1 is the witness. After he tenders his witness, the argument, whatever it is between the presenting officer and the defense representative, how come the MW1 witness makes any argument before the inquiry officer? Lordship will have a look at the last paragraph of that report. During argument, MW1 informed that he has received verbal complaints about the incident. That means the MW1 was again asked something at the time of argument, which is not part of the inquiry process.
Okay.
So, in my respectful submission, my lord, no loss has been caused to the bank. It is a finding.
No loss is caused to the bank, that's all right, but you have deposited the amount, therefore there is no loss.
No. No. I am on the charge, issue of charge. They are saying that I have embezzled, that there was embezzlement of money. Now, to prove that charge, was it not incumbent on the part of the bank to place before the inquiry officer the record of the account statement, showing that on such and such day money was received, but it was not deposited on that particular.
See, the property, departmental property, standard of property, the property.
Exactly, my lord. To my lord, to come to that conclusion.
Okay, all right.
Even to have a probable view of that, where is the minimum evidence to show that money was not deposited? Yeah, I am a receiving cashier. I received money on 2 dates. That is how the money came. But on that day you received and on that day you did not credit can be established only from the account statement, not from anywhere else, my lord. Even to have
No,
that,
your letter is there admitting the entire fact.
but it is obtained. That is that has been he has explained in before the inquiry at the last
No,
day of inquiry.
whether you have made any objection at the time of exam,
No,
when the document was exhibited, whether you have raised any objection.
it was no, because I have. If your lordship goes through the departmental, what is called bipartite settlement, it says there is a provision. Bipartite settlement. That extra copy was given to your lordship on the last day. It is bipartite settlement of 2020, 2002. Perhaps এইমাত্র দিলু তো if your lordship permits me to, I'll mark that because I forgot that particular clause.
You have already pointed out.
No, that is 5J regarding this explanation, how my explanation has to be considered. There is a provision in the bipartite settlement. এইমাত্র দিলু
Yes.
If your lordship hands it over to me for the time being, because I have to find out, because I don't have that extra copy. It was already given to your lordship. I'm reading, my lord. Clause 10 of the bipartite settlement. In all cases in which action under clause 4, 6, or 8 may be taken, the proceeding held shall be entered in a book kept specially for the purpose, in which the date on which the proceedings are held, the name of the employee proceeded against, the charge or charges, the evidence on which they are based, the explanation and the evidence, if any, tendered by the said employee. So, his explanation in respect of the charges will have to be considered by the inquiry officer.
Okay. Part
Clause 10.
part and so part part part
একটু ফেলো রাখি যাবে আপু হেরা যাবে lordship has closed the hearing.
judgment is that
number one,
no, that's all right. Finally, really advocate that too. How the executive and about the students who are already there.
is running without following the guidelines. We are getting that
from this account. Providing the food.
No, 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 no NGO, my lord. The NGO part is over. Now the district committee is maintaining, and the deputy commissioner is the chairman of that committee. He can look after the food also directly. Students are there, my lord, no doubt, but they our my lord, genuineness is in doubt. Therefore, that another writ petition is pending before my lordship, my lord. That can be decided in that issue, but only for the students, my lord, for the sake of students, my lord, we are as a my lord praying before this. My lord, my lord, it is, my lord, it is not a. It is in our pleading, my lord. We have not said that we are not the principal, my lord. We have said that the my lord, our issue of the principal has been, my lord, question. No, no, my learned friend is asking question to me, my lord. That is not fair, my lord. That is not fair, my lord. My lord, I am submitting fairly before my lord, my lord. My lord, my respect. My lord, we are not playing, we are very fair, my lord, in the proceeding that we are the present principal. Then who is the principal in the school, my lord? Who has appointed the principal, sir? Let them show, my lord. My lord, this is not correct statement, my lord. This is our writ, my lord, and we have already filed another writ petition before this honorable court, my lord, wherein this honorable court initially passed an interim order restraining them from going for fresh election. Later on, my lord, that interim order has been vacated, and thereafter,
Okay.
my lord,
Yeah.
my lord,
Yes. Now inspector is the principal of the school.
my lord.
Okay. Then no.
Yes, yes.
We'll so then why don't you no. Then why don't you make payment of the election? That's all right. If you are the in charge of the school, principal of the school, you make payment. We will direct you. Then deputy commissioner will make payment. We'll pass the order. Then Mr. Dhore, your affidavit will be available on which day? 1 week. Okay, we will see later. Today we are only passing interim order for restoration of the electricity. Nothing else. Okay.
My lord, for the food, my lord. For the inspector, it can also be done. My my
That would be kept.
my lord, my learned friend has made a very serious allegation. But for paragraph 10, my lord, I have in paragraph 10, my lord, I have big respect for my senior friend, my lord. I never made any misleading statement. In paragraph 10, I have stated in details my position, my lord. That is available. Reading,
The rest of
my
the matters, that may be taken from the court master.
my
Monday, my lord, 2 p.m. At 2 p.m., my lordship will be. On Monday, my lord, at 2 p.m., my lord. Yes, it was the matter, my lord, in that line. It was the, in that line, I have no. My lord,
No, is it necessary to issue so cause notice before suspension?
for 3 months, within 3 months, they have to issue the so-called notice. That has not been
No, you were submitting that before placing him under suspension, so cause notice has not been issued. Is it provided in the rule? Is it? Madam, let it be on
Monday
Monday.
at 2 p.m. Monday at 2 p.m.
My lord, I think
Pardon? Take a date from him.
matter
Maybe.